Hello. I think I'm on. So, we are going to be discussing the decision. Well, it hasn't actually been released, but Politico. Roe Wade. Politico has gotten a. Sorry, I'm trying to do a bunch of things all at once. So Politico is reporting. Let me see if I can put this on screen. So a draft opinion from. Oh, you guys probably can't even hear me. Can you hear me now? That should be better. Should have used the microphone, huh? So Politico is reporting that they got a draft opinion from the Supreme Court that shows they are going to by the way, if anybody wants to come on to the live stream to discuss these things, please DM me. And I invited Lance to come on, but honestly, he was too upset, and I understand why. Hey, Chris. Yeah. So Chris says there's already protesters in DC. Not surprised. Chris, you should come on. I'm going to DM you the link for you to come on so we can discuss this. Where's Chris? I know I have Chris here somewhere. There he is, Chris. Click on the link, Chris. So Lance, who is a lawyer, Chris is being a wimp. Hey, Luke Jackson. Yeah, so what happened, Lance is a lawyer, and I think he, like me, understands that actually almost bigger than the opinion is the leak. We should probably look at so this is Politico's thing. How rare is a Supreme Court breach? Very rare. Court watchers can't recall a previous time when a draft opinion was publicly disclosed before a decision. Yeah, so in a handful of cases, hints about deliberation have slipped out. That doesn't surprise me. But in 1972, an story detailed the internal wranglings. Yeah, detailing the internal wranglings has happened. But actually leaking the opinion itself. So this is the opinion. Let me see if I can share it. Are you guys seeing the opinion? No, you're not seeing the opinion. I want to share the opinion. Come on. Why can't I? Okay. So I'm going to share Chrome tab. So this is the opinion. So let me talk about how things like this happen. The Supreme Court takes cases on what's called a writ of certiorari. And when I believe at least 4 justices agree to hear a case, then they grant a writ of certiorari. And that's what the opinion means when it says on writ of certiorari to the United States Court of Appeals for the Fifth Circuit. So this case obviously worked its way up from the Fifth Circuit, and what happens after the case is heard is the 9 justices go in to discuss the opinion, and they discuss it. I believe the junior justice starts and it goes to the Chief Justice last, I believe. But I might be confusing this with the procedure for the Sanhedrin, where definitely it starts from the junior elder. And so they take a vote, and if they take a vote, and it's whatever. I mean, if it's 5-4 and the Chief Justice is not part of the majority, it's still the decision is whatever the vote is, right? So the Chief Justice doesn't like get an extra vote. What the Chief Justice does do is he first of all, he's always considered the senior justice, even if he's the first. It's the first. He just came onto the court, which happened with Roberts. They used to elevate justices to be Chief Justice, and because they didn't want the Senate double hearing, they stopped doing that. Anyway, tell me if you guys are interested in particular things. I'm just going to try to explain things as best I can. And if anybody wants to come on with me, please do DM me and come on, because just me speaking is boring. Anyway, so Clarence Thomas is the senior justice right now. And what happens is that if the Chief Justice is part of the majority, the Chief Justice assigns who will write the majority opinion. And if not, the senior justice that's in the majority, which usually would be Clarence Thomas, or I guess whoever the liberal justice would be after him, the senior justice gets to pick who writes the opinion. And so they decide who writes the majority opinion, who writes the minority opinion, if there is one. In very rare cases, they will print a per curiam opinion, which doesn't have somebody's name on it. Any justice can always write concurring or dissenting opinion. And sometimes this gets really weird because some justices will agree with some parts and other. So drafts get circulated, right? And each justice has 4 clerks. So they end up circulating the draft, and they circulate the draft, and just making sure everything's fine. And the various justices decide what they're going to do. This is going to be a crazy ride one way or another. Yeah, it is. But honestly, the fact that this was this was leaked the way it was is really shocking. It's very, very shocking, because the being a clerk of the Supreme Court is basically like the greatest thing that can happen to you as a young lawyer, because it guarantees you're going to be one of the top lawyers in the country. It's one of the most prestigious things in the world. And frankly, they only take from basically Harvard and Yale, maybe a few other schools in the top there. Whoever leaked this, I can only imagine it was, in fact, a clerk. What would be really crazy is if it was Ketanji Brown Jackson, because obviously, I'm guessing now that she was confirmed, she gained access to this stuff. Ooh, wow! If it was an actual justice who did this, and it can be proven, um, that would be, I think, cause for impeachment, because there's no way you could continue. There's no way you could continue. It's just crazy. There's no way you could continue. Um, I'm guessing people know who did it, because it must be somebody who's really passionate about this. My guess, and this is just a wild guess, but my guess is what happened is, so like I said, there's a lot of back and forth, and justices change their opinion. There's actually a lot of like said about how, for example, Brown ultimately became the because the justices do in fact um, convince each other of things, right? My guess is, and so this is the first draft that Alito wrote in February, on February 10th. My guess is what was going on is that possibly the Chief Justice um, had decided that he was going to um, switch sides and go with the majority and write a milder opinion. And if you're the type of person who wants to see this undone, you want the at most 5-4 opinion that can be heavily criticized. And I'm guessing Alito's first draft is pretty much your best bet out of anything that's going to happen after that. And maybe what happened was that Roberts offered to switch sides and write the opinion and write a milder opinion. And this is being leaked because that the whoever leaked it is hoping that it will stay 5-4, or there will be some sort of I mean, there's no way it's going to be retracted, especially after the leak. In fact, I could see the leak causing more conservative justices to move over. But I mean, Breyer, Sotomayor, Kagan, and are not gonna move over. The only person who might move over, I think, would be Roberts. But yeah, I haven't read the full opinion yet. I just figured I would do it on here if people are interested. But this leak is a body blow. It really is. It's a body blow to our government. Lance, I wanted him to come on, but honestly, he said he felt too sick. The fact that this was leaked made him sick. And uh, as somebody who follows the court and has gone to law school, I'm not a lawyer. I just went to law school for way too long. um, the this, I mean, this is really a huge blow to the integrity of the court, because this is going to really affect how well the justices will work together in the future, and how they're going to work together with their clerks. Because um, the person who did this damaged the relationship the justices have with their clerks. Again, I mean, I can't imagine it was actually Jackson who did this. That's like, it's one of these crazy scenarios I have in my mind. It must have been a clerk. It must have been, because I can't imagine a justice being that dumb. But this is part of the problem of Roe. This is part of why why the conservative justices have wanted so much. People, I mean, there are people who want abortion to be outlawed. That's not what this is going to do, right? Overturning Roe does not outlaw abortion. And I think people had staked their hopes on it way too much. I was actually surprised that Casey, apparently, according to this, Casey is going to be overturned as well, because what happened was that Casey basically gutted Roe, and Roe v. Wade isn't actually about abortion anymore as a precedent. Yes, it's still precedent, but it's not really a precedent about abortion anymore. I know that sounds crazy. So this actually happened back when McCain was running against um, Barack Obama, and their vice presidential nominees were Palin and Biden. And I remember this was 2008. I remember Sarah Palin went on Katie Couric, and she was asked to explain Roe. And she gave an obviously rehearsed answer that was given to her by an attorney, which was completely right. And Biden gave a completely wrong answer, which is what everybody thinks Roe is about, right? And so Biden was wrong, Palin was right. Everybody made fun of Palin for giving the wrong answer when Biden gave the right answer. And this pissed me off to no end. So my thinking was we were probably going to eventually get Roe overturned, Casey upheld, and the hope would be that the fact that Roe was overturned would get people to be less emotional on the pro-life side. It's funny, but Ruth Bader Ginsburg said the same thing I'm going to say right now, which I think any intelligent person, which Ruth Bader Ginsburg wasn't one, knew. The decision of Roe actually has been a huge mistake. And I think that's what that is what Alito says, because it politicized the issue, an issue that should have remained in the political branches. Like, I skimmed some of it, like Alito basically says. And if you guys want to look at the opinion yourself, I'm going to put a link into the chat. So there's the link. And politicized the court, and Scalia. I don't think he was actually on there. I want to say he wasn't. He may was. I don't think Scalia was. Let me see. Roe v. Wade. The judges on Roe v. Wade were. The majority was Blackmun, joined by Berger, Douglas, Brennan, Stewart, Marshall, and Powell. Dissent White, joined by Rehnquist. Yeah, Rehnquist was on it. And Rehnquist said it was a horrible decision. And it was overruled partially by Planned Parenthood versus Casey. And so what Ginsburg said is what's right, which is that if it would have been a lot better if it had just been left to the political branches and not made a constitutional issue, because it's made it such a huge voting thing for conservatives specifically. So they I thought what would happen is that Roe would be overturned, Casey would remain, and basically we would have a little bit of a step. But I guess let's read this. Thomas E. Dobbs, State Health Officer of the Mississippi Department of Health, et al. Petitioners versus Jackson Women's Health Organization et al. On writ of certiorari to the United States Court of Appeals for the Fifth Circuit. So what happens is a trial court hears a case. It can be appealed to the Court of Appeals, right? And we have nine circuits, or is it 10 circuits? Now I'm forgetting. Or it might even be 11 circuits. Anyway, we have too few circuits. So it can go to the circuit courts, and usually the Supreme Court will only take an appeal if there are circuit courts which are disagreeing with each other, which obviously is easy to have here because Roe is so controversial. Justice Alito delivered the opinion of the court, and since it's a draft, it's not telling you who concurred with it. Maybe it would tell at the end who's supposed to be in concurrence, does it? So usually there's a syllabus at the beginning written by the court clerk, which actually summarizes, it's unofficial, but it summarizes the court case and tells you what the votes were and all the specifics. This is an appendix. So I think Politico said that it was 5-4 with Roberts being on against it. Anyway, let's keep on reading the court case. So Justice Alito delivered the opinion of the court. Abortion presents a profound moral issue on which Americans hold sharply conflicting views. Some believe fervently that a human person comes into being at conception and that abortion ends an innocent life. Others feel just as strongly that any regulation of abortion invades a woman's right to control her own body and prevents women from achieving full equality. Still others in a third group think that abortion should be allowed under some, but not all circumstances, and those within this group hold a variety of views about the particular restrictions that should be imposed. So basically he's starting off by basically going over why Casey overturned the trimester structure that the court put in place under Roe. For the first 185 years after the adoption of the Constitution, each state was permitted to address the issue in accordance with the views of its citizens. Then in 1973, this court decided Roe v. Wade, and it gives a citation. Even though the Constitution made no mention of abortion, the court held that it confers a broad right to obtain one. It did not claim that American law or the common law had ever recognized such a right, and its survey of history ranged from the constitutionally irrelevant. So again, he's taking the conservative tack. The liberals, I'm sure, will be like, oh, it matters and history matters and whatever. But that is its discussion of abortion in antiquity to the plainly incorrect, such as its assertion that abortion was probably never a crime under the common law. After cataloging a wealth of information having no bearing on the meaning of the Constitution, the opinion concluded with a numbered set of rules, which, much like those that might be found in a statute enacted by a legislature. So again, it's like stopping a legislature. Under this scheme, each trimester of pregnancy was regulated differently, but the most critical line was drawn at roughly the end of the second trimester, which at the time corresponded to the point at which a fetus was thought to achieve viability. That is, the ability to survive outside the womb. Although the court acknowledged that state had a legitimate interest in protecting potential life, it found that this interest could not justify any restrictions on pre-viability abortions. The court did not explain the basis for this line, and even abortion supporters have found it hard to defend Roe's reasoning. One prominent constitutional scholar wrote that he would vote for a statute very much like the one the court ended up drafting if he were a legislator, but his assessment of Roe was memorable and brutal. Roe was not constitutional law at all and gave almost no sense of an obligation to try to be. Let's see who wrote this. This is J. Eli. Haven't heard of him. The Wages of Crying Wolf, a comment on Roe v. Wade in 1973. At the time of Roe, 30 states still prohibited abortion at all stages. In the years prior to that decision, about a third of the states had liberalized their laws, but Roe abruptly ended that political process. It imposed the same highly restrictive regime on the entire nation, and it effectively struck down the abortion law of every single state. And they cite Lawrence Tribe, I'm guessing just to make him feel bad. Lawrence Tribe is a character. As Justice Byron White aptly put it in his dissent, the decision represented the exercise of raw judicial power, and it sparked a national controversy that has embittered our political culture for a half century. See Ruth Ginsburg speaking in a judicial voice. NYU Law Review. Roe halted a political process that was moving in a reform direction, and thereby, I believe, prolonged divisiveness and deferred stable settlement of the issues. Obviously, he's almost trolling with these citations, which I don't mind. By the way, if you guys have questions, please do ask. And if anybody watching wants to come on, DM me. Eventually, in Planned Parenthood of Southeastern Pennsylvania versus Casey, the court revisited Roe, but the members of the court split three ways. 2 justices expressed no desire to change Roe in any way. That's Stevens and Blackmun, apparently. 4 others wanted to overrule the decision in its entirety, and that would be Rehnquist, Scalia. It's not saying who the other 4 were. Other 2. And the 3 remaining justices who jointly signed the controlling opinion took a third position, plurality opinion of O'Connor, Kennedy, and Souter. And these types of plurality opinions, especially when they have lots of different numbers, are really horrible decisions. Their opinion did not endorse Roe's reasoning, and it even hinted that one or more of its authors might have reservations about whether the Constitution protects a right to abortion. But the opinion concluded that stare decisis, which is precedent, legal precedent, which basically says that judges are very reluctant to overrule a ruling, which calls for prior decisions to be followed in most instances, required adherence to what is called Roe's central holding that a state may not constitutionally protect fetal life before viability, even if that holding was wrong. Anything less, the opinion claimed, would undermine respect for this court and the rule of law. Well, that went out the window. Paradoxically, the judgment in Casey did a fair amount of overruling. Several important abortion decisions were overruled in toto, and Roe itself was overruled in part. Casey threw out Roe's trimester scheme and substituted a new rule of uncertain origin under which states were forbidden to adopt any regulation that imposed an undue burden on a woman's right to have an abortion. The decision provided no clear guidance about the difference between a due and an undue burden. But the 3 justices who authored the controlling opinion called the contending sides of a national controversy to end their national division by treating the court's decision as the final settlement of the question of the constitutional right to abortion. Obviously, that didn't happen. As has become increasingly apparent in the intervening years, Casey did not achieve that goal. Americans continue to hold passionate and widely divergent views on abortion, and state legislatures have acted accordingly. Some have recently enacted laws allowing abortion with few restrictions at all stages of pregnancy. Others have tightly restricted abortion beginning well before viability. And in this case, 26 states have expressly asked this court to overrule Roe and Casey and allow the states to regulate or prohibit pre-viability abortions. Before us now is one such state law. The state of Mississippi asks us to uphold the constitutionality of a law that generally prohibits an abortion after the 15th week of pregnancy, several weeks before the point at which a fetus is now regarded as viable outside the womb. In defending this law, the state's primary argument is that we should reconsider and overrule Roe and Casey, and once again allow each state to regulate abortion as its citizens wish. On the other side, respondents and the Solicitor General. So the Solicitor General represents the government of the United States. It's basically Biden's administration attorney. Ask us to reaffirm Roe and Casey, and they contend that the Mississippi law cannot stand if we do so. Allowing Mississippi to prohibit abortions after 15 weeks of pregnancy, they argue, would be no different than overruling Casey and Roe entirely. So this is an interesting thing for them, a brief for respondents, because generally what you would want if the court is going to rule against you, you want to distinguish and say, oh, but you don't need to overrule Casey and Roe. And they were betting. I mean, the Solicitor General was betting that it was not going to be overruled, which doesn't seem like that's what happened. And this quoting them in saying that, yeah, you have to overrule Casey and Roe in order to rule this way, is his way of saying, yeah, you can't distinguish this, right? They contend that no half measures are available and that we must either reaffirm or overrule Roe and Casey. So obviously he wants to overrule both of them. We hold that Roe and Casey must be overruled. And yeah, that's a sentence. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. So what the Due Process Clause of the 14th Amendment does is it says that the states cannot deny due process to any of their citizens, and the Supreme Court has said that that incorporates the Bill of Rights, so which applies only to the federal government, to the state governments as well. So, yeah, so the right to privacy, which is inferred out of the Bill of Rights, is incorporated by the 14th Amendment into actually being regulating the states as well. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. And because the Supreme Court has basically made the 9th and 10th Amendments absolutely meaningless, that they have to... So a bunch of bad decisions has made the Supreme Court make a bunch of other bad decisions. And so we have a weird case law where things which you would think are explicit, like the 9th and the 10th Amendment, don't actually do what they obviously say. And actually parts of the 14th Amendment, I would say. Yes, I think the civil rights cases, that is a particular case by the Supreme Court from many years ago. It was 1868, I'm going to say, called the civil rights cases. Justice Harlan was right when he dissented in that, and they should be overturned, but nobody but me wants to go there. Anyway, so that's why he's going off this whole 14th Amendment thing. The right to abortion does not fall within this category. Until the latter part of the 20th century, such a right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, 3/4 of the states made abortion a crime at all stages of pregnancy. The abortion right is also critically different from any other right that this court has held to fall within the 14th Amendment protection of liberty. Roe's defenders characterized the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. But abortion is fundamentally different, as both Roe and Casey acknowledged, because it destroys what those decisions called fetal life and what the law now before us describes as an unborn human being. Stare decisis, the doctrine on which Casey's controlling opinion was based, does not compel unending adherence to Roe's abuse of judicial authority. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement of the abortion issue, Roe and Casey have inflamed debate and deepened division. He's obviously right. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and the limitations upon it are to be resolved, like most important questions in our democracy, by citizens trying to persuade one another and then voting. And this is Scalia and Casey. Scalia's dissents are really worth reading. He's not my favorite justice. Thomas is my favorite justice, but he had a sharp tongue. That is what the Constitution and the rule of law demand. The act at issue in this case, Mississippi's Gestational Age Act, see Mississippi Code, contains this central provision: except in a medical emergency or in the case of a severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks. The act defines gestational age to be the age of an unborn human being as calculated from the first day of the last menstrual period of the pregnant woman. Wow, that's really early. The first day of the last menstrual period of the pregnant woman. Yeah, that's really early. To support this act, the legislature made a series of factual findings. It began by noting that at the time of enactment, only 6 countries beside the United States permitted non-therapeutic or elective abortion on demand after the 20th week of gestation. The legislature then found that at 5 or 6 weeks gestational age, an unborn human being's heart begins beating. At 8 weeks, the unborn human being begins to move in the womb. At 9 weeks, all basic physiological functions are present. At 10 weeks, vital organs begin to function, and hair, fingernails, and toenails begin to form. At 11 weeks, an unborn human being's diaphragm is developing, and he or she may move about freely in the womb. Well, that's going to trigger the gender activists. How dare they gender the fetus? And at 12 weeks, the unborn human being has taken on the human form in all relevant respects. I'm just going to check to see if anybody is interested in coming on to my live stream or not. Apparently not. Okay. Anybody interested is still invited, and comments or questions are also invited. Okay. Where were we? Yeah. It found that most abortions after 15 weeks employ dilation and evacuation procedures, which involve the use of surgical instruments to crush and tear the unborn child. And it concluded that the intentional commitment of such acts for non-therapeutic or elective reasons is a barbaric practice, dangerous for the maternal patient, and demeaning to the medical profession. So this is the partial birth abortion thing. Yeah. Respondents are an abortion clinic, Jackson Women's Health Organization, and one of its doctors. On the day the Gestational Age Act was enacted, respondents filed suit in federal district court against various Mississippi officials, alleging that the act violated this court's precedent establishing a constitutional right to abortion. The district court granted summary judgment in favor of respondents and permanently enjoined enforcement of the act, reasoning that viability marks the earliest point at which the state's interest in fetal life is constitutionally adequate to justify a legislative ban on non-therapeutic abortions, and that 15 weeks gestational age is prior to viability. The Fifth Circuit affirmed, we granted certiorari to resolve the question whether all pre-viability prohibitions on elective abortions are unconstitutional. Petitioners' primary defense of the Mississippi Gestational Age Act is that Roe and Casey were wrongly decided, and that the act is constitutional because it satisfies rational basis review. So rational basis review is the lowest standard of review. Any act of the legislature has to at least have a rational basis, or the courts can throw it out. So I got a DM from somebody who apparently doesn't want to think. Why do you say this leak is an absolute body blow to our government? What is the significance of the leak itself? So what happens is that the justices privately discuss decisions, and there's all kinds of horse trading that goes on. I think there was a real reason why Scalia was such good friends with Ginsburg, was because it matters a lot when 9 people are sitting around a table discussing things, how congenial, how heated, how friendly they are with each other. And when the decisions are being passed around, judges do actually convince each other, right? They do actually change their mind. And part of being a judge on the Supreme Court is helping to craft opinions in ways that hopefully means they will stand for a long time. And that's why you get things like per curiam decisions, which means the entire court decides to issue this decision without anybody putting their name to it. That's how you get unanimous opinions. The more divided the opinion is, the more concurrences and dissents there are, the more parts there are, and you'll get these really bad decisions, and they're really bad decisions where somebody will write a 5-part decision, right? And like 3 of the parts will have a majority of justices sign on to it, and 2 of the parts will not. So those 3 parts are controlling, and the other 2 parts are considered dicta. It makes it really, really hard for other judges to carry out that decision. It makes one of the most important things for a court decision is for people to be able to read it, to understand what it says, to agree with its reasoning, and to apply it in generally so that people know what the law is. It's a really important part of the law that when people go to court, they should be able to expect who should win in a particular case, right? That expectation of the law being the way the court says is actually what gives the courts their legitimacy, right? The courts don't actually have any way of enforcing their decisions, really. Their decisions, especially the appellate courts and the Supreme Court, their legitimacy is based on people thinking, well, the justices said this, and everybody who's smart, who thinks about it, who reads their decision, says, yeah, this makes sense. And that lawyers throughout the country, and judges especially throughout the country, know what the law is, basically, so that when somebody comes to their lawyer and says, will I win this case? Will I lose this case? The better that lawyers actually know whether they will win or lose at trial, makes the justice system work better. Okay, it's one of the most important things that a judge's decision can do, is make clear to everyone who would lose and who would win, right, in the future. That process of coming together, sharing opinion drafts, and revising drafts, agreeing with each other, it having the various clerks draft statements, include footnotes, take out footnotes. This is the inner working of our legal system at its most critical stage, right? This leaking what's going on there destroys a lot of trust. It opens up this process and makes everybody think, oh, well, once this first draft goes out of my office or off my computer, now it could become public, right? It just changes that deliberative process completely. The amount of damage that this leak has done to the Supreme Court is astounding. There would have been less damage if one of the clerks had taken out a gun and shot one of the justices, honestly. As far as the legal process, it's like somebody pouring sugar into your gas tank. That's basically what they did. They poured sugar into the gas tank of our nation. And yeah, I have no idea what Roberts as Chief Justice is responsible for the administration of the court. I don't know what they're going to do about this. I'm guessing they're going to lock down things, because this PDF, I mean, it looks like it's an actual PDF, but it looks like a scan. It's not like, but I don't know what Politico did to it. So it's not pictures taken by somebody's cell phone. I'm not even sure the clerks are allowed to have their cell phones inside the Supreme Court. I don't know if anybody's allowed to have cell phones inside the Supreme Court or not. They might have to put them in a secure area when they come in and take them when they leave. I'm guessing they have somewhat secured special cell phones. I don't know. But yeah, however this got snuck out, it's a huge deal. It's a really huge deal. I don't know how Roberts is going to prevent it. I mean, at the very least, you have four clerks for each justice. So that's 45 people who have to have access to these decisions, or on page 8 when I come back. So you'll see this stamp here, right? So it was circulated February 10th. So what happens is the Chief Justice gets it, and then by seniority, and each one like checks off that they got it, And I don't know exactly how it's done, how they mark it up. I don't know if the person, I mean, no, it actually looks like this was scanned because I see, um, yeah, it looks like this was scanned because it looks, if you look at the top left, you'll see there's, it looks like the paper mark. So somebody maybe printed a hard copy and took it out of the Supreme Court. They're gonna have to figure out how to deal with this. If the person who leaked it is lucky, nobody will be able to prove who did it. But I mean, I'm guessing there are video cameras all over the Supreme Court building, which will be scoured, maybe. Whoever did this, it's, yeah, this is amazingly, it's destroying the ability of the justices to deliberate, and that's just huge. That's just absolutely huge. Yeah. So we were on page 8. I think we were here. We begin by considering the critical question whether so this is part 2, and what could possibly happen is that justices would be like, I concur in parts 2, 3, 4, whatever, and then have a partial dissent. That's the type of thing that happens when they write their dissents and they write their concurrences and things like that. Yeah. Okay. We begin by considering the critical question whether the Constitution properly understood confers a right to obtain an abortion. Skipping over that question, the controlling opinion in Casey reaffirmed Roe's central holding based solely on the doctrine of stare decisis. But as we will explain, proper application of stare decisis required an assessment of the strength of the grounds on which Roe was based. See infra. We therefore turn to the question that the Casey plurality did not consider, and we address the question in 3 steps. First, we explain the standard that our cases have used in determining whether the 14th Amendment's reference to liberty protects a particular right. Second, we examine whether the right at issue in this case is rooted in our nation's history and tradition, and whether it is an essential component of what we have described as ordered liberty. Finally, we consider whether a right to obtain an abortion is supported by other precedents. A1. So, like I said, this is where they name the sections so that various justices can decide to sign on with, not sign on with. Sometimes a justice will say, I'll sign on if you say so and so. Constitutional analysis must begin with the language of the instrument, Gibbons versus Ogden, so 1824. So this is the originalist thing, which obviously the liberal justices disagree with, but now we have a 6-3 originalist majority, which offers a fixed standard for ascertaining that what our founding documents means. J. Story, Commentaries on the Constitution, 1833. The Constitution makes no express reference to a right to obtain an abortion, and therefore those who claim that it protects such a right must show that the right is somehow implicit in the constitutional text. Roe, however, was remarkably loose in its treatment of the constitutional text. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned. See citation. And that privacy right, Roe observed, had been found to spring from no fewer than 5 different constitutional provisions: the First, Fourth, Fifth, Ninth, and 14th Amendments. He's overstating this. First of all, the Ninth Amendment pretty much doesn't exist. The First Amendment, freedom of religion, that's been argued, but really, the argument is that the Fourth and Fifth Amendment. So it started with a law that prohibited condoms. I think that was it. Condoms were illegal in some states, and I forget what the case was. And the Supreme Court went, okay, you have no right to be in people's bedrooms. If they want to buy condoms, butt out, right? And they said that that's under the privacy right, Fourth and Fifth Amendments, and then that gets incorporated in the 14th Amendment. So that was the idea of privacy, and then that got extended to the relationship between a woman and her doctor, and that was the idea, right? That the Constitution doesn't allow the states to get in the middle of that. And then it was extended also to include abortion, which the pro-life argument is it involves a third person, right? Yeah, I mean, I don't take the normal pro-life stance myself, but at the very least, I think Roe was definitely wrongly decided. I really assumed that Roe would be overturned, but Casey would not, and that was my expectation. But the court's decision left open at least 3 ways in which some combination of these provisions could protect the abortion right. One possibility was that the right was founded in the Ninth Amendment's reservation of rights to the people. Another was that the right was rooted in the First, Fourth, and Fifth Amendment, or in some combination of those provisions, and that this right had been incorporated into the Due Process Clause of the 14th Amendment, just as many other Bill of Rights provisions had by then been incorporated. And a third path was that the First, Fourth, and Fifth Amendments played no role, and that the right was simply a component of the liberty protected by the 14th Amendment's Due Process Clause. Roe expressed the feeling that the 14th Amendment was the provision that did the work, but its message seemed to be that the abortion right could be found somewhere in the Constitution, and that specifically its exact location was not of paramount importance. The court's words were as follows: this right of privacy, whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or as the district court determined in the Ninth Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. The Casey court did not defend this unfocused analysis, and instead grounded its decision solely on the theory that the right to obtain an abortion is part of the liberty protected by the 14th Amendment's Due Process Clause. We discuss the theory in depth below, but before doing so, we briefly address one additional constitutional provision that some of respondents' amici, so amici curiae, literally friends of the court, are people who submit briefs to the court arguing one way or another. And in fact, they tend to be very, well, it's kind of like how prominent podcasters get a lot of people emailing them stuff, right? And they end up not actually doing their own research. Like Libs of TikTok isn't watching TikTok videos all day looking for people. What she's doing is she's getting lots of people emailing her, and she decides out of that. Pretty much the same thing happens at the Supreme Court with the amici curiae. See also a brief of equal protection constitutional lawyers, law scholars as amici curiae. Neither Roe nor Casey saw fit to invoke this theory, and it is squarely foreclosed by our precedents, which establish that a state's regulation of abortion is not a sex-based classification and is thus not subject to the heightened scrutiny that applies to such classifications. The regulation of a medical procedure that only one sex can undergo does not trigger heightened constitutional scrutiny unless the regulation is a mere pretext designed to effect an invidious discrimination against members of one sex or the other. Yeah, the whole heightened scrutiny thing, honestly, I agree with Thomas. It's all bullshit. And as the court has stated, the goal of preventing abortion does not constitute invidiously discriminatory animus against women. Honestly, this is more of a political argument than it is a legal argument. Accordingly, laws regulating or prohibiting abortion are not subject to heightened scrutiny. Rather, they are governed by the same standard of review as other health and safety measures. So basically, he's saying this in order to prevent what would be a slew of new cases, people arguing based on this. I assure you, as soon as people have already gotten to work trying to figure out how to undo this. So with this new theory addressed, we turn to Casey's bold assertion that the abortion right is an aspect of the liberty protected by the Due Process Clause of the 14th Amendment. The underlying theory on which this argument rests, that the 14th Amendment's Due Process Clause provides substantive as well as procedural protection for liberty. So there's two types of due process: substantive due process and procedural due process. Again, legal jargon that I think is unduly stressed. And a lot of this is because of all the precedent and the ways things have been done. And a lot of times judges will construct things in such a way so that what people think is reasonable will actually be the decision, but that's not how the courts got there, right? And they do this for a lot of reasons, and honestly, I think we need bolder overturning of decisions like the civil rights cases. But can you imagine what would happen if a Republican majority overruled the civil rights cases? The first consists of rights guaranteed by the first 8 amendments. These amendments originally applied only to the federal government. But this court has held that the Due Process Clause of the 14th Amendment incorporates the great majority of these rights and thus makes them equally applicable to the states. The second category, which is the one in question here, comprises a select list of fundamental rights that are not mentioned anywhere in the Constitution. In deciding whether a right falls in either of these categories, the court has long asked whether the right is deeply rooted in our history and tradition, and whether it is essential to our nation's scheme of ordered liberty. That's a citation, yeah. And in conducting this inquiry, we have engaged in a careful analysis of the history of the right at issue. Justice Ginsburg's opinion for the court in Timms versus Indiana. he's kind of trolling with the Ginsburg stuff. Is a recent example. In concluding that the Eighth Amendment's protection, like Justice Ginsburg never gets quoted by anyone because she was not a very good justice at all. In fact, in a quantitative analysis, she came in dead last in both ways. They did two quantitative analyses to figure out who are the most cited justices, and she came in dead last out of all the justices in U.S. history. She was really bad, really, really bad, incredibly bad at her job. Anyway, in concluding that the Eighth Amendment protecting against excessive fines is fundamental to our scheme of ordered liberty and deeply rooted in this nation's history and tradition, her opinion traced the right back to Magna Carta, Blackstone's commentaries, and 35 of the 37 state constitutions in effect at the ratification of the 14th Amendment. A similar inquiry was undertaken in McDonald, which held that the 14th Amendment protects the right to keep and bear arms. Now he's just trolling. The lead opinion surveyed the origins of the Second Amendment, the debates in Congress about the adoption of the 14th Amendment, the state constitutions in effect when that amendment was ratified. At least 22 of the 37 states protected the right to keep and bear arms, federal laws enacted during the same period, and other relevant historical evidence. So this is part of the thing of the leftists. They don't care about the reasoning. They just want what they want. So they want to get rid of the right to bear arms. And so they do all kinds of stupid things. And yeah, he's so it. They try to write out the right to bear arms from the Constitution and write in abortion. So he's going off the right to bear arms stuff because that's where their arguments against incorporating things are. Only then did the opinion conclude that the framers and ratifiers of the 14th Amendment counted the right to keep and bear arms among those fundamental rights necessary to our system of ordered liberty. Yeah, and this is, of course, Thomas, who I love. Timms and McDonald concerned the Constitution, whether the 14th Amendment protects rights that are expressly set out in the Bill of Rights, and it would be anomalous if similar historical support were not required when a putative right is not mentioned anywhere in the Constitution. Thus, in Glucksberg, which held that the Due Process Clause does not confer a right to assisted suicide, the court surveyed more than 700 years of Anglo-American common law tradition and made clear that a fundamental right must be objectively deeply rooted in this nation's history and tradition. So what the leftists will do is actually cite court cases from other countries and other legal systems, which the traditionalists obviously don't do. If anybody watching wants to come on the stream with me, please do DM me. You are quite welcome. Historical inquiries of this nature are essential whenever we are asked to recognize a new component of the liberty protected by the Due Process Clause, because the term liberty alone provides little guidance. Liberty is a capacious term, as Lincoln once said, we all declare for liberty, but in using the same word, we do not all mean the same thing. I wonder where he said that. Collected works, address at a sanitary fair. Okay. In a well-known essay, Isaiah Berlin reported that historians of ideas had cataloged more than 200 different senses in which the term had been used. I have no idea who Isaiah Berlin is. In interpreting what is meant by the 14th Amendment's reference to liberty, we must guard against the natural human tendency to confuse what that amendment protects with our own ardent views about the liberty that Americans should enjoy. That is why the court has long been reluctant to recognize rights that are not mentioned in the Constitution. Substantive due process has at times been a treacherous field for this court, and it has sometimes led the courts to usurp authority that the Constitution entrusts to the people's elected representatives. As the court cautioned in Glucksburg, we must exercise the utmost care whenever we are asked to break new ground in this field, lest the liberty protected by the due process clause be subtly transformed into the policy preferences of the members of this court. On occasion, when the court has ignored the appropriate limits imposed by respect for the teachings of history, it has fallen into the freewheeling judicial policymaking that characterizes discredited decisions such as Lochner. Yeah, talk about bad decision. The court must not fall prey to such an unprincipled approach. Instead, guided by the history and tradition that map the essential components of our nation's concept of ordered liberty, we must ask what the 14th Amendment means by the term liberty. When we engage in that inquiry in the present case, the clear answer is that the 14th Amendment does not protect the right to an abortion. This is true regardless of whether we look at to the amendment's due process clause or its privileges or immunities clause. Some scholars and justices have maintained that the privileges or immunities clauses is the provision of the 14th Amendment that guarantees substantive rights and a bunch of decisions. But even on that view, such a right would need to be rooted in the nation's history and tradition. I think he's including this note in order to forestall a debate there, which, I think Thomas is probably because, Until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. Zero. None. No state constitutional provision had recognized such a right. Until a few years before Roe was handed down, no federal or state court had recognized such a right, nor had any scholarly treatise of which we are aware. And although law review articles are not reticent about advocating new rights, the earliest article proposing a constitutional right to abortion that has come to our attention was published only a few years before Roe. What year was that? 68, apparently. Yeah. Not only was there no support for such a constitutional right until shortly before Roe, but abortion had long been a crime in every single state. At common law, abortion was criminal in at least some stages of pregnancy and was regarded as unlawful and could have very serious consequences at all stages. American law followed the common law until a wave of statutory restrictions of the 1800s expanded criminal liability for abortions. By the time of the adoption of the 14th Amendment, 3/4 of the states had made abortion a crime at any stage of pregnancy, and the remaining states would soon follow. Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. It is therefore important to set the record straight. Just checking to see. we begin with the common law under which abortion was a crime, at least after quickening, i.e., the first felt movement of the fetus in the womb, which usually occurs between the 16th and 18th week of pregnancy. The exact meaning of quickening is subject to some debate. Quick child, life child, brief of American Historical Association and Organizations of American Historians. Quick and quickening consistently meant the women's perception of fetal movement. We do not wade into this debate. First, it suffices for present purposes to show that abortion was criminal by at least the 16th or 18th week of pregnancy. Second, as we will show during the relevant period, the period surrounding the enactment of the 14th Amendment, the quickening distinction was abandoned as states criminalized abortion at all stages of pregnancy. The eminent common law authorities, Blackstone, Koch, Hale, and the like, all described abortion after quickening as criminal. Henry de Bracton's 13th century treatise explained that if a person has struck a pregnant woman or has given her poison, whereby he has caused an abortion, if the fetus be already formed and animated, and particularly if it be animated, he commits homicide. So this gets into a whole biblical thing of when life begins, and the Jewish position is severely misstated by a lot of people who try to use the Jewish position as some sort of justification for abortion, which I think is bad. Sir Edward Coke's 17th century treatise likewise asserted that abortion of a quick child was murder if the child be born alive, and a great misprision if the child dieth in her body. Misprision referred to some heinous offense under the degree of felony. Two treatises by Sir Matthew Hale likewise described abortion of a quick child who died in the womb as a great crime and a great misprision. And writing near the time of adoption of our Constitution, Blackstone explained that abortion of a quick child was by the ancient law homicide or manslaughter, and at least a very heinous misdemeanor. And Blackstone's is like considered the basic commentary treatise that lawyers go to. There's a bunch of people watching. Nobody's commenting or asking questions. Comment or ask questions, people. English cases dating all the way back to the 13th century corroborate the treatise's statements that abortion was a crime. In 1732, for example, Eleanor Baer was convicted of destroying the fetus in the womb of another woman and thereby causing her to miscarry. For that crime and another misdemeanor, Baer was sentenced to 2 days in the pillory and 3 years imprisonment. Although a pre-quickening abortion was not itself considered homicide, it does not follow that abortion was permissible at common law, much less that abortion was a legal right. Removal of common law's harsh sanctions did not represent an acceptance of suicide. Quite to the contrary, in the 1732 case mentioned above, the judge said of the charge of abortion, with no mention of quickening, that he had never met with a case so barbarous and unnatural. Similarly, an indictment from 1602, which did not distinguish between a pre-quickening and post-quickening abortion, described abortion as pernicious and against the peace of Our Lady the Queen, her crown and dignity. that the common law did not condone even pre-quickening abortions is confirmed by what one might call a proto-felony murder rule. Hale and Blackstone explained a way in which a pre-quickening abortion could rise to the level of a homicide. Hale wrote that if a physician gave a woman with child a potion to cause an abortion, and actually that's how most abortions were done before surgical abortions, was with various poisons. And the woman died. It was a murder because the potion was given unlawfully to destroy her child within her. As Blackstone explained, to be murder, a killing has to be done with malice aforethought, either express or implied. So this is part of the thing of, if you strike a person and it's legal, why, thank you, Ben. Mighty Mouse says, woohoo, this is awesome. I'm not sure I would describe it as awesome. I wanted to see Roe overturned. I would have very much preferred that the leaking didn't happen, that's for sure. And I would have liked it to be a 6-3 decision as opposed to a 5-4 decision, which I'm guessing the leak partially is in order for that not to happen. And honestly, if we had justices who cared about the country, I would have hoped they would have worked together to have a unanimous decision which was helped punt this problem out of the courts. The courts should not be in the business of deciding things which are political footballs. The Roe did a lot of damage to my views. I'm not part of the people who think that that life begins at conception. I'm not part of the people who think that all abortions should be illegal. But Roe was an incredibly bad decision. And the results of it are obvious. And at some point, the court had to get out from under it. Unfortunately, this 5-4 decision that was leaked is probably the worst way that could have happened. So what I was trying to explain is that if you hit a person and it's an illegal hitting of that person, right? You punch a person when you're not supposed to. Like you're not boxing, right? If you're boxing and it's legal boxing and that person dies, that's not murder. It might be manslaughter, it's not murder. If you hit a person with what would be implied malice, right? So there's the mens rea requirement. So you're doing something against the law. Even if you didn't mean to kill that person, it still can be murder because you shouldn't have hit that person to begin with, okay? And apparently Blackstone is saying that because abortion is illegal, then the mother being killed, that would be homicide, or not just negligence. It would be murder. And from that, he's trying to derive that abortion itself was illegal, which makes sense. Who intended to kill one person accidentally killed a different person. If one shoots at A and misses him but kills B, this is murder because of the previous felonious intent, which the law transfers from one to the other. The same is the case where one lays poison for A and B, against whom the prisoner had no malicious intent, takes it and it kills him. This is likewise murder. So also if one gives a woman with child a medicine to procure abortion, and it operates so violently as to kill the woman, this is murder in the person who gave it. Notably, Blackstone, like Hale, did not state that this proto-felony murder rule required that the woman be with quick child, only that she be with child. And it is revealing that Hale and Blackstone treated abortionists differently from other physicians or surgeons who caused the death of a patient without any intent of doing the patient any bodily hurt. These other physicians, even if unlicensed, would not be guilty of murder or manslaughter. But a physician performing an abortion would, precisely because his aim was an unlawful one. In sum, although common law authorities differed on the severity of punishment for abortions committed at different points in pregnancy, none endorsed the practice. Moreover, we are aware of no common law case or authority, and the parties have not pointed to any, that remotely suggests a positive right to procure an abortion at any stage of pregnancy. In this country, the historical record is similar. The most important early American edition of Blackstone's commentary reported Blackstone's statement that abortion of a quick child was at least a heinous misdemeanor, and that edition also included Blackstone's discussion of the proto-felony murder rule. Manuals for justices of the peace, printed in colonies in the 18th century, typically restated the common law rule on abortion, and some manuals repeated Hale's and Blackstone's statements that anyone who prescribed medication unlawfully to destroy the child would be guilty of murder if the woman dies. And there's a lot of citations there. The few cases available from the early colonial period corroborate that abortion was a crime. In Maryland in 1652, for example, an indictment charged that a man murderously endeavored to destroy or murder the child. Sorry, this is before Webster. By him begotten in the womb, 1891. Maybe that's not before Webster. And in the 19th century, courts frequently explained that the common law made abortion of a quick child a crime. The original ground for drawing a distinction between pre- and post-quickening abortions is not entirely clear, but some have attributed the rule to the difficulty of proving that a pre-quickening fetus was alive. At that time, there was no scientific methods for detecting pregnancy in its early stages. And thus, as one court put it in 1872, until the period of quickening, there's no evidence of life, and whatever may be said of the fetus, the law has fixed upon this period of gestation as the time when the child is endowed with life, because fetal movements are the first clearly marked and well-noted evidence of life. In contemplation of law, life commences at the moment of quickening, at the moment when the embryo gives the first physical proof of life, no matter when it first received it. The Solicitor General offers a different explanation of the basis for the quickening rule, namely that before quickening, the common law did not regard a fetus as having a separate and independent existence. I had never actually read this type of quickening analysis, and frankly, I think it would have made a good way of making a less egregious Roe standard that more people could have lived with. Good night, Ben. Yeah. I will stick around as long as people are watching, and people are watching. Please like and subscribe, people, by the way. But yeah, so let's keep on going. Yeah, I think it would have been a good way of punting Roe in a less thing way. So somebody who refuses to name himself has some really good questions, though. What are possible ways this plays out, and which do you think is most likely? Ooh, so the decisions usually come out in June, towards the end of June. I don't know what the current decision looks like. I don't know what the leak is going to do to the court's deliberations. It might completely short circuit it. It might backfire on the leaker, and you might actually get somebody like Justice Kagan, who wants to protect the court, try to fashion some sort. I don't know what the decision that's going to come out of the court is going to look like. I don't know what this leak is going to. I don't know what it looks like now, even though Politico says that right now it's still 5-4. I don't know why the person who leaked it. They may have thought this was a way of somehow doing something, of short circuiting a process somehow. In my dream world, first the clerk and I. Okay, let's do my dream world. Dream world. It was Ketanji Brown Jackson who leaked it. She's still not on the court yet. And in my dream world, she would get impeached. And in my dream world, Roberts and the 3 liberal justices would decide that in order to try to repair this breach, they would fashion together a unanimous decision which punts Roe and maybe tries to, in a very, yeah, we won't allow, like, no abortions first. Well, I don't even know how they would fashion it, but fashion something that would be somewhere in the middle and slowly move away as opposed to abruptly. This draft is basically the pro-life dream, and there's going to be a lot of feminists with their hair on fire. I remember when I was in law school, and at the time I wore a yarmulke and had a beard, and it was very obvious that I was an Orthodox Jew. I went to a discussion between a woman from People for the American Way and a libertarian from the Reason Foundation about the future of Roe. And they were discussing things, and she kept on saying things like, she kept on saying weird things like that, abortion could become illegal in California. And I said to her, do you seriously think abortion could ever become illegal in California? She's like, yeah, of course. And the guy from Reason Foundation, obviously knowing my position, um, said, asked me, do you think it's possible? And I tried in as secular way as possible to say, not before the Messiah comes. I said, barring some supernatural event, of course not. And I mean, the idea, and this is what all these people are going to be screaming about. They're going to be saying, no, you can't get an abortion in Los Angeles. And it's like, that's not even close to what's going on in this decision. But God knows how the New York Times and the wokerati and Twitter are going to you know look at this. The first question is this actually going to be the decision that comes out of the court? If it is the decision that comes out of the court, they're saying outright the states can do whatever they want. That the federal courts are going to, the Supreme Court and the federal courts are going to stay out of it completely. This would definitely contribute to the great sorting. But what's going to happen after that, I have no idea. What's the likeliness of this being enough motivation for the left to pack the court? Honestly, yeah, they might use it as a reason to do it. They will certainly run on it in November, and they will pretend that things like house races matter. Look, they're desperate. I think November is going to be a slaughter in the House against the Democrats, because a lot of suburban mothers are talking about voting Republican. So yeah, they're going to run on it. I don't know what they're going to do politically. Honestly, I don't know what they're going to do politically. This is going to make a greater amount of sorting. I think it's going to show a lot of people that the craziest things that the left says, like they're going to make abortion illegal in Los Angeles, right? That's just idiocy speaking. And it's idiocy that people, even today, I'm sure there's people on MSNBC today saying we won't be able to have abortions, right? And so the actual impact of it is actually going to be mostly negligible. It really is, because in the states that abortion is going to be made illegal, abortions, that's not where the abortions are, right? That's not how many abortions. Let me see if I can find how many abortions by state in, let's say, 2020, right? Let me see if I can find states by state abortion statistics. I can't seem to find per state abortions, but I guarantee you the vast majority of abortions are being had in California and New York. Just by population, that's likely, right? Um, and so this Supreme Court decision is not going to affect at all California and New York, because all it's doing is sending it back to the states, and um, in California and New York, it's going to remain legal. And honestly, as far as the states that are really against it, it's not like they have open abortion clinics there anyway. People already travel to other states, and people can travel to other states to get abortions, right? And as far as like the pill, the day after pill, that is gonna be, I think that's still going to be available everywhere. So again, this isn't something that I think is actually going to change things for people that much. If this becomes a state by state thing, is it enough of a final straw for pro-choicers to actually pack up and leave the red moderate states and move to blue states, or will people just protest and not much else? I think this is going to contribute to. I think this is going to definitely contribute to the sorting, but I mean, yeah. So this wonderful person did, in fact, give me state by state. So the abortion rate. So this is abortion rate by number of clinic. No, okay. The abortion rate per person, I think this is. The highest states are New Jersey, New York, Maryland. Those are not going to make it illegal. Florida, I could see Florida banning third trimester abortions. I don't even know what the law is in Florida right now, but I'm guessing third trimester abortions only, with the exception of rape and incest. I can't imagine it's going to go that, Florida's a purple state. Connecticut, bright blue. Georgia, Georgia is, and if people want to see this, let me put this in the thing. So Georgia has a pretty high abortion rate. Again, it's a purple state. Rhode Island, blue. Illinois, blue. California, blue. Nevada, even the red parts of Nevada, like this is a state where they have legalized prostitution. North Carolina's purple, I believe. Michigan, blue. Pennsylvania, purple. Kansas, okay, now we're getting into the red states. Washington, so Washington, there's the rural thing divide. Hawaii's very blue. Oregon's really blue. New Mexico's purplish. Vermont is blue. Colorado, purplish. I don't know what's going to happen with Colorado. But by the time we get to the average, like it's the red states that are all, so the abortion rate at Texas is 9.4, right? And like Wyoming, South Dakota, so Mississippi, Missouri, these have the lowest abortion rates. And frankly, people are just gonna go across state and just like people in Ireland and In England, people are just going to go across state lines and do it. Let's see. Anthony says, I found the common law part interesting. The quickening distinction wouldn't hold up with modern science, but most people I talk to say viable life is reasonable, which is not that far off of it. Yeah, I mean, there are better ways this could be done. If Republicans regained the presidency in both houses, couldn't they ban abortion nationally? No, definitely not. No, definitely not. So this is part of what the conservative side has been trying to limit, which is the federal power to regulate things. And there's no way a federal regulation of abortion is going to be upheld by any court. The left won't do it because they have no principles whatsoever, and the right won't do it because it would be moving the wrong way in as far as federalism. So that's a pipe. That's one of the pipe dreams that the pro-lifers have, and these are the silly things that people in our silly political environment say. No, not gonna happen. Not gonna happen. So yeah, the links. Unfortunately, if you guys try to put a link in the chat, even I don't get to see it because when YouTube decides they don't like something, and they generally don't like anything. Texas had 55,000 abortions. That's a lot more than I thought. What is the legal protection for states to have the right? So the way our federal system works is that the states have what's called general police power. They get to regulate anything they want. That's their right. The federal government has enumerated powers, right? So they can only regulate those things that the Constitution gives the federal government power over. And what happened was that the Interstate Commerce Clause got blown up in crazy ways. In fact, was that what Lochner? I forget what Lochner was. Yeah, so Lochner was a landmark decision of in which the court ruled that New York state law setting maximum working hours for bakers, violating the bakers' right to freedom of contract under the 14th Amendment. So they overturned a state law, right? Because they said it's basically very similar to Roe. What was I thinking? I'm thinking of the wheat case. So it's known as the stitch in time that saved 9. Let me see if I can find it. The stitch in time that saved 9. Yeah. So that was West Coast Hotel versus Parrish. And here I will put the link if you guys want to read on it. And so what happened was that a lot of these states, what happened was that the left wanted federal control over everything. And basically the Federalist Society, one of its aims has been to rein in the federal government by limiting the Interstate Commerce Clause. And that's what a lot of things like Heller, McDonald, like a lot of these, Lopez was one of the decisions. trying to limit federal power. So yeah, that's how they have it. John Yoo predicted this. I don't like him, but he said the quiet part out loud during Barrett's nomination in a Hoover interview. I was shocked at the time, but he was right. Predicted what? Predicted the leak or predicted the decision? I personally thought Roe would be overturned. I did not think Casey would be overturned, but apparently that's what's going on. Do you think this leak could push back the decision date? I don't know what it will do to the decision date. I don't think it would push it back. The decisions are usually all released in June towards and the term ends for the summer, right? So their calendar is pretty set. And I'm guessing it's possible that the decision might actually come a lot quicker because of this leak. And that might be part of the reason whoever leaked it may have leaked it. Yeah. So if you guys have questions, if anybody who knows me wants to come on, you know how to DM me. I can have you on and we can discuss it. Otherwise, I am going to continue with the reading of the case. Okay, where were we? But the case on which the Solicitor General relies for this proposition also suggested that the criminal law's quickening rule was out of step with the treatment of prenatal life in other areas of the law, noting that to many purposes in reference to civil rights, an infant in ventre sa mère, I've never heard of that, is regarded as a person in being. Okay? At any rate, the original ground for the quickening rule is of little importance for present purposes because the rule was abandoned in the 18th century. During the period, treatise writers and commentators criticized the quickening distinction as neither in accordance with the result of medical experience nor with the principles of the common law. In 1803, the British Parliament made abortion a crime at all stages of pregnancy and authorized the imposition of severe punishment. One scholar has suggested that Parliament's decision may partly be have been attributable to the medical man's concern that fetal life should be protected by the law at all stages of gestation. In this country during the 19th century, the vast majority of states enacted statutes criminalizing abortion at all stages of pregnancy. By 1868, when the 14th Amendment was ratified, 3/4 of the states, 28 out of 37, had enacted statutes making abortion a crime, even if it was performed before quickening. Some scholars assert that only 27 states prohibited abortion at all stages. Those scholars appear to have overlooked Rhode Island, which criminalized abortion at all stages in 1861. The amicus brief for the American Historical Association asserts that only 26 states prohibited abortion at all stages, but that brief incorrectly excludes West Virginia and Nebraska from its count. Yeah, so he's arguing with the Amici Curiae. Okay. Of the 9 see Appendix A, and this is the first court case I remember having an appendix, but I guess it's necessary. Of the 9 states that had not yet criminalized abortion at all stages, all but one did so by 1910. The trend in the territories that would become at the last, no thank you, 13 states was similar. All of them criminalized abortion at all stages of pregnancy between 1850 and 1919. Appendix B. Wow. By the end of the 1950s, according to the Roe Court's own count, statutes in all but 4 states and the District of Columbia prohibited abortion however and whenever performed, unless done to save or preserve the life of the mother. This overwhelming consensus endured until the day Roe was decided. At that time, also by the Roe Court's own count, a substantial majority, 30 states, still prohibited abortion at all stages except to save the life of the mother. And when you get down to it, almost any court is going to any law is going to be incredibly difficult to enforce. They're always going to have a life of the mother exception, and you're always going to have a physician who's willing to say she'll commit suicide. Her life is at stake if I don't abort. That's the way a lot of people get away with it in a lot of places. Hopefully the leaker gets ousted. Hopefully the leaker doesn't become some sort of national hero, which is what I fear is actually going to happen. I pray to God it wasn't a justice who leaked. Honestly, the only justice who could have leaked this that I would if Breyer, if this is his last act and he leaked it, that would be crazy. Especially since there's nothing you can do to him. If it was Jackson, wow, I think she would be impeached. I hope, and frankly, that would be best case scenario. Much better than a clerk doing it. I have no idea how this is going to play out. I don't. I could see a Republican House passing a law banning crossing state lines for abortions. It passing the Senate is less likely, and like those Obamacare votes may just be a symbolic act. And who's going to actually enforce it? Do you really think the FBI is going to be certainly not under Democrats, right? Do you really think the FBI is gonna be? I don't think so. So again, I think this is mostly just a political fight. I really do. The inescapable conclusion is, did I skip? So let's, this overwhelming consensus endured until the day Roe was decided. At that time, also by the Roe Court's own count, a substantial majority, 30 states, still prohibited abortion at all stages except to save the life of the mother. And though Roe discerned a trend toward liberalization in about 1/3 of the states, those states still criminalized some abortions and regulated them more stringently than Roe would allow. In short, the court's opinion in Roe itself convincingly refutes the notion that the abortion liberty is deeply rooted in the history or tradition of our people. The inescapable conclusion is that a right to abortion is not deeply rooted in the nation's history and traditions. On the contrary, an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. The court in Roe could have said of abortion exactly what Glucksberg said of assisted suicide, attitudes toward abortion have changed since Bracton, but our laws have consistently condemned and continue to prohibit that practice. So the brackets are them changing it a little bit. Respondents and their amici have no persuasive answer to this historical evidence. Neither respondents nor the Solicitor General disputes the fact that by 1868, the vast majority of states criminalized abortion at all stages of pregnancy. See brief for the petitioners. Instead, the respondents are forced to argue that it does not matter that some states prohibited abortion at the time Roe was adopted or when the 14th Amendment was adopted. But that argument flies in the face of the standard we have applied in determining whether an asserted right that is nowhere mentioned in the Constitution is nevertheless protected by the 14th Amendment. Not only are respondents and their amici unable to show that a constitutional right to abortion was established when the 14th Amendment was adopted, but they have found no support for the existence of an abortion right that predates the latter part of the 20th century. No state constitutional provision, no statute, no judicial decision, no learned treatise. The earliest sources called to our attention are a few district court and state court decisions decided shortly before Roe, and a small number of law review articles from the same period. And yeah, I think the earliest was 1968. Yeah, apparently. A few of respondents' amici muster historical arguments, but they are very weak. The Solicitor General repeats Roe's claim that it is doubtful abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. But as we have seen, great common law authorities like Bracton, Coke, Hale, and Blackstone all wrote that a post-quickening abortion was a crime, and a serious one at that. Moreover, Hale and Blackstone and many other authorities following them asserted that even a pre-quickening abortion was unlawful and that, as a result, an abortionist was guilty of murder if the woman died from the attempt. Instead of following these authorities, Roe relies largely on two articles by a pro-abortion advocate who claimed that Coke had intentionally misstated the common law because of his strong anti-abortion views. These articles have been discredited, and it has come to light that even members of Jane Roe's legal team did not regard them as serious scholarship. An internal memorandum characterizes this author's work as donning the disguise of impartial scholarship while advancing the proper ideological goals, which basically is what all these people do. Did I lose my viewers? Because if I did, I might go to bed. No, actually, apparently just YouTube doesn't like my viewers, apparently. The Solicitor General next suggests the history supports an abortion right because the common law's failure to criminalize abortion before quickening means that at the founding and for decades thereafter, women generally could terminate a pregnancy, at least in its early stages. But the insistence on quickening was not universal. And regardless, the fact that many states in the late 18th and early 19th century did not criminalize pre-quickening abortions does not mean that anyone thought the states lacked the authority to do so. When legislatures began to exercise the authority as the century wore on, no one, as far as we are aware, argued that the laws they enacted violated a fundamental right. This is not surprising, since common law authorities had repeatedly condemned abortion and described it as an unlawful act without regard to whether it occurred before or after quickening. Another amicus brief. So I'm not used to Supreme Court justices arguing with amicus briefs. This might partially be because it was in the first draft. And I don't think it's a mistake that whoever leaked this leaked the first draft. Relied upon by the respondents, tried to dismiss the significance of the state criminal statutes that were in effect when the 14th Amendment was adopted by suggesting that they were enacted for illegitimate reasons. According to this account, which is based almost entirely on statements made by one prominent proponent, important motives for the laws were the fear that Catholic immigrants were having more babies than Protestants, and that the availability of abortion was leading white Protestant women to shirk their maternal duties. Resort to this argument is a testament to the lack of any historical support for the right that Roe and Casey recognized. This court has long disfavored arguments based on alleged legislative motives. The court has recognized that inquiries into legislative motives are a hazardous matter, even when an argument about legislative motive is backed by statements made by legislators who voted for a law. We have been reluctant to attribute those motives to the legislative body as a whole. What motives one legislator to motivates one legislator to make a speech about a statute is not necessarily what motivates scores of others to enact it. Here, the argument about a legislative motive is not even based on statements by legislators, but on statements made by a few supporters of the new 19th century abortion laws, and it is quite a leap to attribute these motives to all the legislators whose votes were responsible for the enactment of those laws. Recall that at the time of the adoption of the 14th Amendment, over 3/4 of the states had adopted statutes criminalizing abortion, usually at all stages of pregnancy, and that from the early 20th century until the day Roe was handed down, every single state had such a law on its books. Are we to believe that the hundreds of lawmakers whose votes were needed to enact these laws were motivated by hostility to Catholics and women? There is ample evidence that the passage of these laws was instead spurred by a sincere belief that abortion kills a human being. Many judicial decisions from the late 19th and early 20th centuries made that point. One may disagree with this belief, and our decisions is not our decision is not based on any review about when a state should regard prenatal life as having rights or legally cognizable interests. But even Roe and Casey did not question the good faith of abortion opponents. And we see no reason to discount the significance of the state laws in question based on these amici's suggestions about legislative motive. Where were we? I'm a college student, not majoring, not going for law, but it seems that like a lot of common law and it being a draft, his reasoning throughout it is pretty trash. No, I don't think it's trash. But that's why it's a draft. I think what he's doing, what often happens is when this court opinion comes out, the dissent writes it in response, and they continue revising and answering each other, and that makes for a much better whole. And he may have in fact been trying to convince at least Roberts to switch on. So no, I don't think his reasoning is trash. He talks a lot about the amici more than I would say is normal. Anthony, this is the great problem with textualism versus original intent. It is a possible splitting point in conservative legal philosophy. Yeah, honestly, so when I was in law school, specifically my constitutional law professor, like this was what he's actually using their arguments against them. So this is what the people who are opposed to this people who are opposed to original intent argue is that you can't really discern legislative intent. And honestly, it's not like the people who talk about originalists, it's almost a straw man, right? To say that originalists are looking for the original intent of the person who drafted the to some extent, yeah. I mean, they look at the legislative history and what was argued as the language was being framed. But they also often just look at what everybody assumed, right? So you can actually get a much better understanding of things by looking at what everybody at the time assumed that the text meant, right? And that's kind of different from the original intent stuff. This is my first look at a major court case and reading the reasoning. No problem. And honestly, if you don't know how this stuff is done, this is mostly being written for lawyers. If you want to read really good court cases, I love Justice Thomas. I just love Justice Thomas. I have not been disappointed by a single one of his decisions yet. Kagan, while I disagree with her, she's pretty smart. Sotomayor is actually pretty smart too. Ruth Bader Ginsburg was a disaster, absolute disaster. The woman should never have become a judge. I don't know if you got to this yet, but he brought up murder with the intention to kill a person A, but it kills person B instead, which gives no reasoning to the point. And the idea is okay. So yeah, I did explain what was going on there. He's trying to prove that that abortion was considered illegal. So we have a basic idea that every crime requires a mens rea and an actus reus. So the actus reus is the actual doing the act, and mens rea is the intent to do a bad act, right? And you don't have to intend to do the act that you actually do. You just have to have what's called mens rea and an evil intent, right? And he's using that person kills A, B, which is basic law, right? If I intend to kill person A and I kill person B, the mens rea is attributable, right? And what the argument for the proto murder, that I guess it was Black, I forget who was making the argument, but whoever was making the argument was saying, since abortion is illegal, there is mens rea there, which can be attributed to the death of the mother, right? And this is pre-quickening, right? And he's using that to prove that the abortion itself is something illegal, right? Because the argument that they're making is that it wasn't a crime under common law, because if it was a crime under common law, then it couldn't have been a right, right? So they're saying no, it wasn't a crime under common law. Well, the people who are arguing that no, it couldn't possibly be a right, are arguing that it was a crime under common law. What level of crime is a whole different thing, but that's what he's doing with that example. He is showing that whatever abortion was, it was something that had a component of illegality to it, which is why it could contribute mens rea. Okay, I hope that's clear. I did go over that earlier. If you might want to rewind. Okay. Instead of seriously pressing the argument that the abortion right itself has deep roots, supporters of Roe and Casey contend that the abortion right is an integral part of a broader entrenched right. Roe termed this a right to privacy, and Casey described it as the freedom to make intimate and personal choices that are central to personal dignity and autonomy. Casey elaborated, at the heart of liberty is the right to define one's own concept of existence, of a meaning, of the universe, and of the mystery of human life. The court did not claim that this broadly framed right is absolute, and no such claim would be plausible. While individuals are certainly free to think and to say that what they wish about existence, meaning, and the universe and the mystery of human life, they're not always free to act in accordance with those thoughts. License to act on the basis of such beliefs may correspond to one of the many understandings of liberty, but it is certainly not ordered liberty. I think he's right. I mean, imagine if you could make your own definitions of what is human life. Actually, I want to. I'll show you guys later when we go to Twitter. But there's this meme. Democrats in 1862, or maybe it was 1852. No, you can't. And it's like the crying Wojak. No, you can't say. You can't say that that's human life, wearing a Confederate hat, and then it says 2021 or 2022. No, you can't. Democrat crying. No, you can't say that's human life. And well, it didn't have blue hair. It should have had blue hair. Okay, ran the number for 2017 abortion data. In the 21 states in which abortion will be largely illegal immediately after the decision is issued, there were 217,030, representing 25% of abortions nationally. I don't know if it's really going to have as much of an impact as people think it is. I really don't, because people are going to find. I mean, how many of those people will still get an abortion, just travel to get it? It's not like it's hard to go to a neighboring state. If you include the 4 states thought likely to ban abortion, the number jumps to 302,520, or 35% of abortions nationally. I think you might be squeezing a bag there. Honestly. Okay. Still a little confused. I can understand if you kill the child, but it kills the mother as well. But if you intend to kill the child and it doesn't kill the mother, then such illegality does not apply. Yes. You're misunderstanding. Yes, you're misunderstanding what he's trying to prove there. Okay. He is only trying to prove that the person who, so the reasoning of the treatise is, so we're on page 31. Let me go back there. Remember where we were, because I will not. Okay, so here on page 18, right? So he is citing from, which treatise is this? Blackstone. Yeah, it was Blackstone. Okay, so Blackstone is explaining, right? So this is Blackstone's reasoning. Blackstone's reasoning is that because abortion is illegal, the person who, and if the mother dies, right? So the mother dies, you have an actus reus, you still need a mens rea because the person wasn't trying to kill the mother. So, but the person had to be doing something that had to intend to do something that had mens rea, right? So his argument is that it's still murder. Why? Because abortion itself is an illegal act, right? So the example I gave was punching, right? If the two of us are boxing and I punch you and God forbid you die, that's not murder. If we're boxing illegally, though, and I punch you and you die, even though I didn't mean to kill you, that's still murder. Why? Because there's an underlying illegal act that I meant to do. So that gives me the mens rea with the actus reus. That makes it a crime. You have to have both parts, right? So what Justice Alito is explaining is that Blackstone is saying that the abortion contributes the mens rea, meaning that abortion itself is an evil act. Abortion itself is something illegal. So he's proving that at the time, according to um, Blackstone, even abortion of a pre-quickened child, right, before quickening, was still considered a something that had mens rea. It was still illegal. That's his point. Okay. Now do you understand what I mean? Okay. Okay. Let's go down to 31. I think we were at. Somebody let me know if I missed it. The standard of time with the ideas of it being legal to have an abortion up to a certain point, then such precedent shouldn't matter. But I do understand where he is trying to go with it. Okay, I'm not sure. Recurring time. So you are just screwing over the poor and disadvantaged. That's part of the argument, honestly. And I think that's part of where the argument is actually correct. Yeah, you are, because the rich people are always going to be able to travel, and they're always going to be able to find a doctor who's going to, in fact, see, this is the thing. I don't think this is the right way of going about getting rid of abortion. That's not because I'm not against abortion. I am against abortion. I think abortion, you're destroying a potential life. And as far as I'm concerned, if you chop down a tree for no good reason, you're already doing something bad, right? But this needed to be taken out of the court system. It really, really needed to be taken out of the court system. And unfortunately, it wasn't. It hasn't been yet. Once it gets punted to actual states, we'll see. There's a lot of economical and societal change that will happen due to this case. I don't know. I honestly don't know. It was an open bleeding sore in our legal system, Roe, and to some extent Casey as well. It politicized the court, and the main reason I wanted Roe overturned is because I wanted the Supreme Court out of the discussion. Where it's actually going to shake out, I'm not sure. I can tell you for sure there's no way it's going to become illegal in California and New York. That's just not going to happen. I think we should look more into fixing the adoption process in foster care. This should possibly come. See, that's not the problem. Unfortunately, that's not the problem at all. There are people willing to, if we're talking about babies, there are people willing to adopt babies, including Down syndrome kids, including kids with all kinds of. There are people willing to adopt. That's not part of the problem here. I agree with Dr. Jordan Peterson when he says by the time you're talking about abortion, you're already many steps beyond where you should be focusing. If somebody doesn't want to have children, first of all, people like societally, I believe in enforced monogamy, and I believe that there shouldn't be premarital sex. Yes, I'm a hypocrite. That's beside the point. People who don't want to get pregnant shouldn't be getting pregnant. You know, I don't think there are very many people talking about making it illegal to have condoms and like the birth control pill and stuff like that, right? So then it becomes a question of people aborting Down syndrome children, most specifically, which I think is incredibly immoral. And it's just, I mean, when you look at the figures, I believe it's Greenland. There are 0 people with Down syndrome in Greenland. And that should tell you something. Yeah. Birth rates will definitely go up. I don't know about that. I really don't. To some extent, I think there might be a few people who will find it harder to get a late term abortion. Maybe a few people who find out they're pregnant really late. I really don't think it's going to be that thing. Jack Johnson, you must be new here. By the way, welcome to the new people, including Glosher. I hope I said that right. It is part of the problem because disabled babies are on the dole for life. Honestly, I mean, no. That is such a horrible, unchristian, unethical way of looking at human life. This is why Christianity opposed abortion since the very beginning, because it was Greek culture to murder babies, and infanticide is still takes place in a lot in China and in India. Abortion is murder. That doesn't make it wrong. Yeah, it does. That's the definition of murder. It's wrong. I understand that abortion is terrible, and there is a free way out for people. Leaving it on the doorsteps of a fire or police station, dumpster, babies should literally never exist. I believe almost all states have safe surrender laws, but even in California, where we definitely have safe surrender laws, this girl at USC, where I went to college, dumped her baby in a dumpster because she didn't want to deal with it. T for tech. No, you didn't lose us. By the way, T, if you want to come on stream, you know how. Well, I'll have to send you a thing, but DM me. I understand that leaving a kid on the steps of the fire station is awful as well. It's just a legal way out. Honestly, I don't think it's awful. I think that if you are a decent person who wants to, you go to sleep, T. If you're a decent person who wants to do what's best for your child, I see absolutely nothing wrong whatsoever with putting your child up for adoption. In fact, I think that's the moral, unselfish thing to do, especially because the people who do adopt will be able to give that child a much better life. And now there are all kinds of open adoptions as well, where people will allow you to still be part of the child's life when they adopt a child, which honestly, I'm not sure that's best for the child or not, but Anthony, could you maybe describe the Jewish law of abortion and the arguments about it? I was interested when you said Shapiro's view is totally un-Jewish. I almost made a video about this. Okay. So, yeah. So Ben Shapiro is a heretic. Under Jewish law, a child that has not yet been born is not considered a full human life. That doesn't mean that it's not prohibited to kill it. It just means that it doesn't have an equal status with a human life, which means that if certainly a Jewish woman, it gets, we don't put many requirements on Gentiles, although this is one of the places where possibly we do have even more stringent for certain. It can get really technical. I don't know how technical you want to get, but let's stick to a Jewish woman, right? If a Jewish woman dies, if a Jewish woman goes to a doctor who tells her that having the child could kill her, she is required by Jewish law to have an abortion because her life is considered more important than the potential life of that child. Okay? Damn, Jewish law is bizarre compared to Christian values. No, I would actually say Jewish law is more well thought out, and Christian values often go with simple gut feelings without actually considering the ramifications, which ends up having people put in horrible situations that haven't been rationally thought out, right? So you're the husband, your wife is giving birth, and the doctor comes out and says, it's your wife or the child. And a Christian is left answering how. And I don't think there is a clear Christian answer to that. There is a very clear Jewish law answer to that. His wife comes first because that child has not yet been born. It's not a full human life. Her life comes first, right? And these are the types of things that in Jewish law we take very seriously, and we want a thought out moral answer to what people should do in cases like this. Circumcision is mutilation, but it is not wrong. I'm not going to get into that. Just it's a whole other thing. And so what Ben Shapiro was at a Q&A, I don't have the Q&A, so you can find it yourself, but I saw it. I don't remember where it was. Somebody asked him, and specifically this person was asking, like, with the names of rabbis and stuff, and it's like, and I expected Ben to have a much better answer than the one he did. His answer was, I don't base my beliefs regarding abortion on Judaism. I base it on biology. That is pure heresy. That is pure heresy. He is picking biology over Judaism. And if he wants to say he's a secular whatever, he can. But to go around claiming you are an Orthodox Jew and just openly disagreeing with Jewish law regarding one of the three cardinal sins, murder. It's one of the three cardinal sins. That's just pure heresy. And the least he could do is what I do, which is I say there are places where I disagree with, and there's a lot of places where I don't actually live up to Jewish law. But he says he defines life beginning at where he thinks scientifically it begins, which is at conception. And that's what a lot of Catholics would agree with. That's not the Jewish concept, right? We have stages of life, and it is forbidden by Torah law. So it is a sin in Judaism. It's called Bal Tashchit, to destroy anything, right? So if I were to destroy this pen because I wanted to, that is prohibited by Jewish law, right? And it's based on the verse that says, when you go to war, you shall not chop down fruit trees, right? Because even when you're going, because you're destroying things for no good reason, right? And we extend that in Judaism to anything. You cannot break a rock for no good reason, right? So you certainly cannot kill a potential life. And yes, that actually does include wasting semen. So that is also prohibited within Judaism if you do it for no good reason. And not going to go too far into that. But certainly, like, you're about to have a child, destroying that potential for human life is definitely forbidden in Judaism. There's no question. The exception is if the life of the mother, who is a full human being, is at stake, where her life comes first. So if a woman refuses to have an abortion and she dies, she's in Judaism, she committed suicide. She committed suicide, right? And if that's a notorious suicide, right? If she, like, it's advertised that she did this, then she should be denied a Jewish burial. Not that rabbis nowadays actually do that, but they're supposed to, right? Deny her a Jewish burial. So what Ben Shapiro is advocating is definitely not. And we have Bible verses which explain exactly, like, so, and there are all kinds of Talmudic discussions where life begins, how you do that, all kinds of stuff like that. But yeah, that's actually really interesting. What about tube tying and vasectomies? So the Bible um, specifically bans castrating animals, and we make an a fortiori kal vachomer to human beings. If you cannot castrate animals, obviously you cannot castrate human beings either. Tube tying, a woman could get her tubes tied if getting pregnant is a danger to her life. Vasectomies, pretty much everybody says there's no way for yeah. Men cannot practice birth control in Judaism. Women can, because their life is at stake. And in fact, a woman is allowed to. So there's a story in the Talmud about a woman who takes what's called kos ikarin, which is a potion which caused women to be infertile, and basically that's allowed, but only because getting pregnant risks her life, and she is not required to risk her life. It's meritorious if she does in order to have children. Men have a requirement to have children. Under Jewish law, women do not have a requirement to have children, because you're not required to give up your life in order to have children. And getting pregnant can be dangerous to women. So women can practice birth control. There are people who say that if, for example, your wife is doing that, you have to divorce her, basically. But that's a whole other thing. Okay. I hope I answered you guys all about that. I might make a video eventually, but it's really complicated, and it gets people misinterpret it constantly, and my pleasure. So yeah. Okay. We were on page 31. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interests of a woman who wants an abortion and the interests of what they termed potential life. But the people of the various states may evaluate those interests differently. In some states, voters may believe that the abortion right should be more extensive than the right that Roe and Casey recognized. Voters in other states may wish to impose tight restrictions based on their belief that abortion destroys an unborn human being. Our nation's historical understanding of ordered liberty does not prevent the people's elected representatives from deciding how abortion should be regulated, nor does the right to obtain an abortion have a sound basis in precedent. Casey relied on cases involving the right to marry a person of a different race, Loving, the right to marry while in prison, Turner, the right to obtain contraceptives, Griswold, and that's what I was talking about. That's where we really started down the line, was with Griswold. The right to reside with relatives, the right to make decisions about the education of one's children, the right not to be sterilized without consent, and the right in certain circumstances not to undergo involuntary surgery, forced administration of drugs, or other substantially similar procedures. Respondents and the Solicitor General also rely on the post-Casey decisions like Lawrence versus Texas and Obergefell. These attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept of its existence prove too much. Those criteria are at a high level of generality could license fundamental rights to illicit drug use, prostitution, and the like. None of these rights has any claim to being deeply rooted in history. What sharply distinguishes the abortion right from the rights recognized in the cases on which Roe and Casey rely is something that both those decisions acknowledged. Abortion destroys what those decisions call potential life and what the law at issue in this regard regards as the life of an unborn human being. None of the other decisions cited by Roe and Casey involve the critical moral question posed by abortion. They are therefore inapposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right does not undermine them in any way. In drawing this critical distinction between the abortion rights and other rights, it is not necessary to dispute Casey's claim, which we accept for the sake of argument, that the specific practices of states at the time of the adoption of the 14th Amendment do not mark the outer limits of the substantive sphere of liberty which the 14th Amendment protects. Abortion is nothing new. It has been addressed by lawmakers for centuries, and the fundamental moral question that it poses is ageless. Defenders of Roe and Casey do not claim that any new scientific learning calls for a different answer to the underlying moral question, but they do contend that changes in society require the recognition of a constitutional right to obtain an abortion. Without the availability of abortion, they maintain people will be inhibited from exercising their freedoms to choose the types of relationships they desire, and women will be unable to compete with men in the workplace and in other endeavors. This is one of the most gross type things people will argue. I'm sorry, but like WTF, workplace, women competing in the workplace is a reason to have an abortion? F you. It's just so insane. And like when leftists make this argument, they make more pro-life people. Americans who believe that abortion should be restricted press countervailing arguments about modern developments. They note that attitudes about the pregnancy of unmarried women have changed drastically, that federal and state laws ban discrimination on the basis of pregnancy, that leave for pregnancy and childbirth are now guaranteed by law in many cases, that the costs of medical care associated with pregnancy are covered by insurance or government assistance, that states have increasingly adopted safe haven laws which generally allow women to drop off babies anonymously, and that a woman who puts her newborn up for adoption today has little reason to fear that the baby will not find a suitable home. They also claim that many people now have a new appreciation of fetal life, and that when prospective parents who want to have a child view a sonogram, they typically have no doubt that what they see is their daughter or son. Trigger the gender people again. Both sides make important policy arguments, but supporters of Roe and Casey must show that this court has the authority to weigh those arguments and decide how abortion may be regulated in the states. They have failed to make that showing, and we thus return the power to weigh these arguments to the people and their elected representatives. We next consider whether the doctrine of stare decisis counsels continued acceptance of Roe and Casey. Stare decisis plays an important role in our case law, and we have explained that it serves many valuable ends. It protects the interests of those who have taken action in reliance on a past decision. It reduces incentives for challenging settled precedents, saving parties and courts the expense of endless litigation. It fosters even-handed decision-making by requiring that like cases be decided in a like manner. It contributes to the actual and perceived integrity of the judicial process, and it restrains judicial hubris and reminds us to respect the judgment of those who grappled with important questions in the past. Precedent is a way of accumulating and passing down the learning of past generations, a font of established wisdom richer than what can be found in any single judge or panel of judges. Apparently, Gorsuch published a book in 2019. I hadn't read it. Yeah, I mean, the funny thing is that these are the types of arguments that people make in order to, like, the left disagrees with all of this. They don't believe in stare decisis at all. Yet now that's what they are thinking of. Okay, I might. Okay, somebody DM'd me something which I might talk about. It's been a while, but can you give a simple explanation between Casey and Roe? I don't want to take too much time up. No problem. Okay, so what happened with Roe was that they said there was a trimester. First of all, they said that there was a right to privacy, which extended Griswold, right? So Griswold basically said you can't regulate how people have sex. That was basically Griswold, right? Like the state does not have the right to regulate people's sex lives. And it was because, like, I think condoms were illegal, or maybe sodomy was illegal, but like something where the state was like coming into your bedroom, right? And basically, I think everybody agrees with Griswold. Stay out of people's bedrooms, right? Roe extended that to the doctor relationship, right? And the idea was that, and they set up this trimester framework, which in the first trimester, they said that it's her body and she gets to decide. And in the third trimester, there's a life there and the state can regulate. And in the second trimester, there is a balance of rights there. And so there are limitations. And so the state cannot impose too much of an undue burden. And this was the framework of Roe, which actually then vice presidential candidate Biden repeated to Katie Couric, and what most people understand Roe to be. What actually happened, though, was in Casey, the courts kind of gutted Roe. That's what my procedure law professor called it, right? Gutting Roe. And Casey versus Planned Parenthood got rid of that trimester thing, right? And it created a different framework, which was and so Roe itself only became a precedent saying that there was a federal interest in protecting the rights of people. And honestly, like, if you're for marijuana legalization, the best thing you could want is for Roe to be overturned, because Roe isn't what governs abortion anymore. It's Casey that does. Okay. But Roe was kept in part, and that part was what made it a federal involvement in the medical decision, right? And frankly, my hope had kind of been that they would overturn Roe completely, yet kind of leave Casey alone for now, which would allow things to be not so crazy and slowly move. But yeah, I believe it was that contraception was illegal in Kentucky at the time. Could be. Yeah, Griswold. I can look up Griswold. Griswold. It was Connecticut. Griswold versus Connecticut. It was a landmark decision in which the court that the concept protects the liberty of married couples to buy and use contraceptives without government restriction. The case involved the Connecticut Comstock law that prohibited any person from using any drug, medicinal article, or instrument for the purpose of preventing conception. The court held that the statute was unconstitutional and that the clear effect of the Connecticut law is to deny disadvantaged citizens access to medical assistance and up-to-date information in respect to proper methods of birth control. By a vote of 7-2, the Supreme Court invalidated the law on the grounds that it violated the right to marital privacy, establishing the basis for the right of privacy with respect to intimate practices. This and other cases view the right to privacy as a right to protection from government intrusion. Yeah. And that, I mean, I think most people nowadays would agree with Griswold. And yeah, it's just, it went, I think it went too far. I mean, I think Roe versus Wade went too far. Okay. We have long recognized, however, that stare decisis is not an inexorable command, and it is at its weakest when we interpret the Constitution. It has been said that it is sometimes more important that an issue be settled than it be settled right. But when it comes to the interpretation of the Constitution, the Greater Charter of our Liberties, which was meant to endure through a long lapse of ages, we place a high value on having the matter settled right. In addition, when one of our constitutional decisions goes astray, the country is usually stuck with the bad decision unless we correct our own mistake. An erroneous constitutional decision can be fixed by amending the Constitution, but our Constitution is notoriously hard to amend. Therefore, in appropriate circumstances, we must be willing to reconsider and, if necessary, overrule constitutional decisions. Some of our most important constitutional decisions have overruled prior precedents. We mentioned 3. In Brown versus Board of Education, the court repudiated the separate but equal doctrine, which had allowed states to maintain racially segregated schools and other facilities. In doing so, the court overruled the infamous decision in Plessy versus Ferguson, along with 6 other Supreme Court precedents that had applied the separate but equal rule. In West Coast Hotel versus Parrish, the court overruled Adkins versus Children's Hospital, which had held that a law setting minimum wages for women violated the liberty protected by the Fifth Amendment Due Process Clause. West Coast Hotel signaled the demise of an entire line of important precedents that had protected an individual liberty right against state and federal health and welfare legislation. See Lochner, and others. Finally, in West Virginia Board of Education versus Barnett, after the lapse of only 3 years, the court overruled Minorville School District versus, I won't even try to say that, and held that public school students could not be compelled to salute the flag in violation of their sincere beliefs. Barnett stands out because nothing had changed during the intervening period other than the court's belated recognition that its earlier decision had been seriously wrong. On many other occasions, the court has overruled important constitutional decisions. We include a partial list in the footnote that follows, and that's a lot of cases. Within these decisions, oh wow, it took a whole page. American constitutional law, as we know it, would be unrecognizable, and this would be a different country. No justice of this court has ever argued that the court should never overrule a constitutional decision, but overruling a precedent is a serious matter. It's not a step that should be taken lightly. Our cases have attempted to provide a framework for deciding when a precedent should be overruled, and they have identified factors that should be considered in making such a decision. In these cases, 5 factors weigh strongly in favor of overruling Roe and Casey: the nature of their error, the quality of their reasoning, the workability of the rules they imposed on the country, their disruptive effect on other areas of the law, and the absence of concrete reliance. Looking at YouTube live stream, there's only 3 to 4 going on that are talking about this topic. I'm surprised you don't have hundreds of people in here listening. I am guessing that I am being downranked by YouTube, because that makes sense. I don't know why, but listening to this while working out is super enjoyable. Thank you for doing this. My pleasure. I will plug my Spotify podcast, Post Platonic, and I do lots and lots of Bible videos and rants, so you are quite welcome to listen to the rest of my stuff, and you're welcome to the channel. Okay, where are we? The nature of the court's error, and I am very glad that you are working out. Keep it up. Good job. An erroneous interpretation of the Constitution is always important, but some are more damaging than others. The infamous decision in Plessy versus Ferguson Supra was one such decision. It betrayed our commitment to equality under the law. It was egregiously wrong on the day it was decided. And as the Solicitor General agreed at oral argument, it should have been overruled at the earliest opportunity. Roe was also egregiously wrong and deeply damaging for reasons already explained. Roe's constitutional analysis was far outside the bounds of any reasonable interpretation of the various constitutional provisions to which it vaguely pointed. Roe was on a collision course with the Constitution from the day it was decided, and Casey perpetuated its errors. And the errors do not concern some arcane corner of the law of little importance to the American people. Rather, wielding nothing but raw judicial power, the court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Casey described itself as calling both sides of the national controversy to resolve their debate, but in doing so, Casey necessarily declared a winning side. Those on the losing side, those who sought to advance the state's interest in fetal life, could no longer seek to persuade their elected representatives to adopt policies consistent with their views. The court short-circuited the democratic process by closing it to the large number of Americans who dissented in any respect from Roe. Roe fanned into life an issue that has inflamed our national politics in general and has obscured with its smoke the selection of justices to this court in particular ever since Scalia. Um, Together, Roe and Casey represent an error that cannot be allowed to stand. Again, if I would have overturned Roe and hinted at a possible future overturning of Casey. As the court landmark decision in West Coast Hotel illustrates, the court has previously overruled decisions that wrongly removed an issue from the people and the democratic process. As Justice White later explained, decisions that find in the Constitution principles or values that cannot fairly be read into that document usurp the people's authority, for such decisions represent choices that the people have never made and that they cannot disavow through corrective legislation. For this reason, it is essential that this court maintains the power to restore authority to its proper possessors by correcting constitutional decisions that on reconsideration are found to be mistaken. The quality of the reasoning. Under our precedents, the quality of the reasoning in a prior case has an important bearing on whether it should be reconsidered. In part 2 of this opinion, we explained why Roe was incorrectly decided, but that decision was more than just wrong. It stood on exceptionally weak grounds. Roe found that the Constitution implicitly conferred a right to obtain an abortion, but it failed to ground its decision in text, history, or precedent. It relied on an erroneous historical narrative. It devoted great attention to and presumably relied on matters that have no bearing on the meaning of the Constitution. It disregarded the fundamental difference between the precedents on which it relied and the question before the court. It concocted an elaborate set of rules with different restrictions for each trimester of pregnancy, but it did not explain how this veritable code could be teased out of anything in the Constitution, the history of abortion laws, prior precedent, or any other cited source. And its most important rule that states cannot protect fetal life prior to viability was never raised by any party and has never been plausibly explained. Roe's reasoning quickly drew scathing scholarly criticism, even from supporters of broad access to abortion. The Casey plurality, while reaffirming Roe's central holding, pointedly refrained from endorsing most of its reasoning. It revised the textual basis for the abortion right, silently abandoned Roe's erroneous historical narrative, and jettisoned the trimester framework. But it replaced that scheme with an arbitrary undue burden test and relied on an exceptional version of stare decisis that, as explained below, this court has never before applied and has never invoked since. Okay, so what were we saying? Alito really isn't holding back on this case. This is a first draft, but yeah, he's a lot of scathing remarks. He's no Scalia. Now, there's a book, Scalia Dissents, which has all the juicy parts. Scalia was really like, he was something else. The weaknesses in Roe's reasoning are well known. Without any grounding in the constitutional text, history, or precedent, it imposed on the entire country a detailed set of rules, much like those that one might expect to find in a statute or regulation. Dividing pregnancy into 3 trimesters, the court imposed special rules for each. During the first trimester, the court announced that the abortion decision and its effectuating must be left to the medical judgment of the pregnant woman's attending physician. After that point, a state's interest in regulating abortion for the sake of a woman's health became compelling, and accordingly, a state could regulate the abortion procedure in ways that are reasonably related to maternal health. Finally, in the stage subsequent to viability, which in 1973 roughly coincided with the beginning of the third trimester, the state's interest in the potentiality of human life became compelling, and therefore a state could regulate and even prescribe abortion except where it is necessary in appropriate medical judgment for the preservation of the life or health of the mother. This elaborate scheme was the court's own brainchild. Neither party advocated the trimester framework, nor did either party or any amicus argue that viability should mark the point at which the scope of the abortion right and the state's regulatory authority should be substantially transformed. Not only did this scheme resemble the work of a legislature, but the court made little effort to explain how these rules could be deduced from any of the sources on which constitutional decisions are usually based. We have already discussed Roe's treatment of constitutional text, and the opinion failed to show that history, precedent, or any other cited source supported its scheme. Roe featured a lengthy survey of history, but much of its discussion was irrelevant, and the court made no effort to explain why it was included. For example, multiple paragraphs were devoted to an account of the views and practices of ancient civilizations where infanticide was widely accepted. When it came to the most important historical fact, how the states regulated abortion, when the 14th Amendment was adopted, the court said almost nothing. It allowed that states had tightened their abortion laws in the middle and late 19th century, but it implied that these laws might have been enacted not to protect fetal life, but to further a Victorian social concern about illicit sexual conduct. Roe's failure even to note the overwhelming consensus of state laws in effect in 1868 is striking, and what it said about the common law was simply wrong. Relying on two discredited articles by an abortion advocate, the court erroneously suggested, contrary to Bracton, Coke, Hale, Blackstone, and a wealth of other authority, that the common law had probably never really treated post-quickening abortion as a crime. It now appears doubtful that abortion was ever firmly established as a common law crime, even with respect to the destruction of a quick fetus. This erroneous understanding appears to have played an important part in the court's thinking, because the opinion cited the lenity of the common law as one of the four factors that informed its decision. After surveying history, the opinion spent many paragraphs conducting the sort of fact-finding that might be undertaken by a legislative committee. This included a lengthy account of the position of the American Medical Association and the position of the American Public Health Association, as well as the vote by the American Bar Association's House of Delegates in February 1972 on proposed abortion legislation. Also noted were a British judicial decision handed down in 1939 and a new British abortion law enacted in 1967. The court did not explain why these sources shed light on the meaning of the Constitution, and not one of them adopted or advocated anything like the scheme that Roe imposed on the country. Finally, after all this, the court turned to precedent. Citing a broad array of cases, the court found support for a constitutional right of personal privacy, but it conflated two very different meanings of the term: the right to shield information from disclosure and the right to make and implement important personal decisions without government interference. Only the cases involving this second sense of the term could have any possible relevance to the abortion issue. And some of the cases in that category involved personal decisions that were obviously very, very far afield. Right to send children to religious school, right to have children receive German language instruction. What remained was a handful of cases having something to do with marriage or procreation, But none of these decisions involved what is distinctive about abortion, its effect on what Roe termed potential life. When the court summarized the basis for the scheme it imposed on the country, it asserted that its rules were consistent with the following: the relative weights of the respective interests involved, the lessons and examples of medical and legal history, the lenity of the common law, and the demands of the profound problems of the present day. Put aside the second and third factors, which were based on the court's flawed account of history, and what remains are precisely the sort of considerations that legislative bodies often take into account when they draw lines that accommodate competing interests. The scheme Roe produced looked like legislation, and the court provided the sort of explanation that might be expected of a legislative body. I'm waiting for the FBI to get involved. I'm not a fan of the FBI, but this could give them some good respect to find the leaker. Overall, the Supreme Court will to keep an even tighter lid on leaks. I don't know if the FBI will be involved. It's the U.S. Marshals, which provide the Supreme Court with security. I'm guessing the U.S. Marshals are the ones who are going to be looking into this. I imagine there are cameras all over the place. I don't know how this was snuck out. It looks like a hard copy was somehow snuck out. Honestly, I could believe that this got out because it was sent to the incoming Justice Jackson, and she may have clerks that are SJWs, because her clerks are still from her previous position. That's my great hope. That would be a best case scenario, was that this slipped out because drafts were circulated to Justice Jackson, and people who normally would not be involved in the process got access to it. If you people are getting bored, tell me if we might move on to Twitter, which is what I'm going to do if I finish this. I'm thinking it was a copy that was printed and then given to Politico to be rescanned into a PDF file. Maybe that would be smart thing to do if you had a whatchamacallit of it. But I don't know. I really don't. Yeah. Okay. Okay. What Roe did not provide was any cogent justification for the lines it drew. Why For example, does a state have no authority to regulate first trimester abortions for the purpose of protecting a woman's health? The court's only explanation was that mortality rates for abortion at that stage were lower than the mortality rates for childbirth. But the court did not explain why mortality rates were the only factor that a state could legitimately consider. Many health and safety regulations aim to avoid adverse health consequences short of death. And the court did not explain why it departed from the normal rules that courts defer to the judgments of legislatures in areas fraught with medical and scientific uncertainties. And even a more glaring deficiency was Roe's failure to justify the critical distinction it drew between pre- and post-viability abortions. Here is the court's entire explanation. With respect to the state's important and legitimate interest in potential life, the compelling point is at viability. This is so because the fetus then presumably has the capacity of meaningful life outside the womb. As Professor Lawrence Tribe has written, so they're just trolling Tribe. Tribe is definitely on the left. I'm pretty sure he's one of these nutsos on the left, if I remember correctly. I hope I'm not mixing him up with somebody else. Political involvement. Oh, hold on. Yeah, so he formed a counter to the Federalist Society. He served as judicial advisor to Barack Obama's 2008 presidential campaign. Yeah, he was involved in 2016 trying to allow the Electoral College not to. Yeah, you can go read his here. I'll put the link in the chat. Yeah, he's a left wing nutso at Harvard, and this is just kind of trolling, really. Clearly, this mistakes a definition for a syllogism. The definition of a viable fetus is one that is capable of surviving outside the womb. But why is this the point at which the state's interest becomes compelling? If, as Roe held, a state's interest in protecting prenatal life is compelling after viability, why isn't the interest equally compelling before viability? Roe did not say, and no explanation is apparent. This arbitrary line has not found much support among philosophers and ethicists who have attempted to justify a right to abortion. Some have argued that a fetus should not be entitled to legal protection until it acquires the characteristics that they regard as defining what it means to be a person. Among the characteristics that have been offered are as essential attributes of personhood are sentience, self-awareness, the ability to reason, or some combination thereof. By this logic, it would be an open question whether even born individuals, including young children, or those afflicted with certain developmental or medical conditions, merit protection as persons. But even if one takes the view that personhood begins when a certain attribute or combination of attributes is acquired, it is very hard to see why viability should mark the point where personhood begins. The most obvious problem with any such argument is that viability is heavily dependent on factors that have nothing to do with the characteristics of a fetus. One is the state of neonatal care at a particular point in time. Due to the development of new equipment and improved practices, the viability line has changed over the years. Okay, the number of viewers is going down. If people have questions and stuff, I will continue going at least for another half an hour. If people leave, I am probably going to stop at midnight here, which is in half an hour. Wait, Katanji get a vote on this? No. If not, then would she be allowed to see the drafts on the subject matter? She doesn't get a vote, that's for sure. I think it's par for the course that all the incoming justices are kind of let in on what the decisions are that are coming up, especially because they're going to need to know this stuff for the coming term. Like, she has to read up what's going on, the things that come up in this term, especially as soon as she's on the court, which will probably be, I believe, she'll get sworn in like in July. I think, I'm not sure. She's going to be responsible for writs of for emergency stays and writs of certiorari and stuff for her seat. And so to get them, I mean, letting her see these drafts, I think, is part of normal thing, which is, yeah, the only thing I can imagine is maybe the cause of how this happened. Yeah. The most obvious problem with any such argument is the viability is heavily dependent on factors that have nothing to do with the characteristics of a fetus. One is the state of neonatal care at a particular point in time. Due to the development of new equipment and improved practices, the viability line has changed over the years. In the 19th century, a fetus may not have been viable until 32 or 33 weeks after conception, or even later. When Roe was decided, viability was gauged at roughly 28 weeks. Today, respondents draw the line at 23 or 24 weeks. So according to Roe's logic, states now have a compelling interest in protecting a fetus with a gestational age of, say, 26 weeks. But in 1973, states did not have an interest in protecting an identical fetus. How can that be? Viability also depends on the quality of the available medical facilities. Thus, a 24-week-old fetus may be viable if a woman gives birth in a city with hospitals that provide advanced care for very premature babies. But if the woman travels to a remote area far from any such hospital, the fetus may no longer be viable. On what ground could the constitutional status of a fetus depend on the pregnant woman's location? And if viability is meant to mark a line having universal moral significance, can it be that a fetus that is viable in a big city in the United States has a privileged moral status not enjoyed by an identical fetus in a remote area of a poor country? In addition, as the court once explained, viability is not really a hard and fast line. A physician determining a particular fetus's odds of surviving outside the womb must consider a number of variables, including gestational age, fetal weight, a woman's general health and nutrition, the quality of the available medical facilities, and other factors. It is thus only with difficulty that a physician can estimate the probability of a particular fetus's survival. And even if each fetus's probability of survival could be ascertained with certainty, settling on a probability of survival that should count as viability is another matter. Is a fetus viable with a 10% chance of survival, 25%, 50%? Can such a judgment be made by a state? And can a state specify a gestational age limit that applies in all cases? Or must this difficult question be left entirely to the individual attending physician on the particular facts of the case before him? Honestly, if I was king of the world, what I would say is a woman is allowed to ask that a child be removed from her womb. But once it is removed from her womb, you can't kill it. You should keep it alive if possible. And I think that's as true at 2 months as it is at 9 months. Well, no, it's definitely a lot more true at 6 or 7 months. But yeah, at the very least, that makes sense. That makes some sense to me. Like, she has a right to have her womb evacuated, but she doesn't have a right to kill the child. But that's actually why we have partial birth abortions, is because they want to kill the child. Because oftentimes this is because the child has Down syndrome or some other condition, and people want to not have that child, and they also don't want it adopted away. If you use the logic of viability changing over time, then wouldn't it make sense that wouldn't it be reasonable that to say at one point in the future, right after conception, then it would be viable? Honestly, yeah. Um, I mean, yeah, it's quite possible that we might get to technology which can make a child viable, right? I mean, we might be able to grow um, completely in vitro. Uh, what about artificial wombs or cadaver wombs in the future? When does a science experiment become a child? Honestly, I am personally sympathetic to the idea that the child has a right to life, but it doesn't have a right to a woman's womb. So I would be perfectly fine with a law that says women are allowed to ask for labor to be induced or cesarean section removal of a child, even at any age. Um, and then, but that doesn't mean you get to kill the child. And that's actually what a lot of these people want, is they don't want the child to be alive. And that's what I think is the fundamental immorality of it. The viability line, which Casey termed Roe's central rule, makes no sense, and it is telling that other countries almost uniformly eschew such a line. The court thus asserted raw judicial power to impose, as a matter of constitutional law, a uniform viability rule that allowed the states less freedom to regulate abortion than the majority of Western democracies enjoy. That then gets into being to intellectually biased over moral and emotional basis with lads, we, and artificial womb. It is just an experiment at that point. I don't understand what you're saying. You must be exercising and using the voice thing, I'm guessing. But yeah, I mean, I think it makes sense to allow women to say, vacate my womb. That makes sense to me. All in all, Roe's reasoning was exceedingly weak, and academic commentators, including those who agreed with the decision as a matter of policy, were unsparing in their criticism. John Hart Ely famously wrote that Roe was not constitutional law and gave almost no sense of an obligation to try to be. Archibald Cox, who served as Solicitor General under President Kennedy, commented that Roe reads like a set of hospital rules and regulations that neither historian, layman, nor lawyer will be persuaded are part of the Constitution. Archibald Cox, Lawrence Tribe, keeps on going back to him, wrote that even if there is a need to divide pregnancy into several segments with lines that clearly identify the limits of governmental power, interest balancing of the form the court pursues fails to justify any of the lines actually drawn. Mark Tushnet termed Roe a totally unreasonable judicial opinion. Despite Roe's weaknesses, its reach was steadily extended in the years that followed. The court struck down laws requiring that second trimester abortions be performed only in hospitals, that minors obtain parental consent, that women give written consent after being informed of the status of the developing prenatal life and the risks of abortion, that women wait 24 hours for an abortion, that a physician determine viability in a particular manner, that a physician performing a post-viability abortion use the technique most likely to preserve the life of the fetus, and that fetal remains be treated in a humane and sanitary manner. Justice White complained that the court was engaging in unrestrained imposition of its own extra-constitutional value preferences. And the United States, as amicus curiae, asked the court to overrule Roe 5 times in the decade before Planned Parenthood versus Casey, and then asked the court to overrule it once more in Casey itself. When Casey revisited Roe almost 20 years later, very little of Roe's reasoning was defended or preserved. The court abandoned any reliance on a privacy right and instead grounded the abortion right entirely on the 14th Amendment's due process clause. The court did not reaffirm Roe's erroneous account of abortion history. In fact, none of the justices in the majority said anything about the history of the abortion right. And as for precedent, the court relied on essentially the same body of cases that Roe had cited. Thus, with respect to the standard grounds for constitutional decision-making, text, history, and precedent, Casey did not attempt to bolster Roe's reasoning. The court also made no real effort to remedy one of the greatest weaknesses in Roe's analysis: its much criticized discussion of viability. The court retained what it called Roe's central holding, that a state may not regulate pre-viability abortions for the purpose of protecting fetal life, but it provided no principled defense of the viability line. Instead, it merely rephrased what Roe had said, stating that viability marked the point at which the independent existence of a second life can, in reason and fairness, be the object of state protection that now overrides the rights of the woman. Why reason and fairness demanded that the line be drawn at viability, the court did not explain. And the justices who authored the controlling opinion conspicuously failed to say that they agreed with the viability rule. Instead, they candidly acknowledged the reservations some of us may have in reaffirming that holding of Roe. The controlling opinion criticized and rejected Roe's trimester scheme and substituted a new undue burden test. But the basis for this test was obscure, and as we will explain, the test is full of ambiguities and is difficult to apply. Casey, in short, either refused to reaffirm or rejected important aspects of Roe's analysis, failed to remedy glaring deficiencies in Roe's reasoning, endorsed what it termed Roe's central holding while suggesting that a majority might not have thought it was correct, provided no new support for the abortion right other than Roe's status as precedent, and imposed a new and problematic test with no firm grounding in constitutional text, history, or precedent. As discussed below, Casey also deployed a novel version of the doctrine of stare decisis. This new doctrine did not account for the profound wrongness of the decision in Roe and placed great weight on an intangible form of reliance with little, if any, basis in prior case law. Stare decisis does not command the preservation of such a decision. Workability. Our president counseled that another important consideration in deciding whether a precedent should be overruled is whether the rule it imposes is workable, that is, whether it can be understood and applied in a consistent and predictable manner. Casey's undue burden test has scored poorly on the workability scale. Problems begin with the very concept of an undue burden. As Justice Scalia noted in his Casey dissent, determining whether a burden is due or undue is inherently standardless. Whether a burden is deemed undue depends heavily on which factors the judge considers and how much weight he accords them. That was just the Scorsese, apparently. The Casey plurality tried to put meaning into the undue burden test by setting out 3 subsidiary rules, but these rules created their own problems. The first rule is that a provision of law is invalid if its purpose or effect is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. But whether a particular obstacle qualifies as substantial is often open to reasonable debate. In the sense relevant here, substantial means of ample or considerable amount, quantity, or size. Huge, and they're using Webster's Unabridged, which is classical textual ways of doing things. Huge burdens are plainly substantial and trivial ones are not, but in between these extremes, there's a wide gray area. This ambiguity is a problem, and the second rule, which applies at all stages of a pregnancy, muddies things further. It states that measures designed to ensure that the woman's choice is informed are constitutional so long as they do not impose an undue burden on the right. To the extent that this rule applies to pre-viability abortions, it overlaps with the first rule and appears to impose a different standard. Consider a law that imposes an insubstantial obstacle but serves little purpose. As applied to a pre-viability abortion, would such a regulation be constitutional on the ground that it does not impose a substantial obstacle? Or would it be unconstitutional on the grounds that it creates an undue burden? Because the burden it imposes, though slight, outweighs its negligible benefits. Casey does not say, and this ambiguity would lead to confusion down the line. And they compare two things. The third rule complicates the picture even more. Under that rule, unnecessary health regulations that have the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion impose an undue burden on the right. This rule contains no fewer than 3 vague terms. It includes the 2 already discussed, undue burden and substantial obstacle, even though they are inconsistent. And it adds a third ambiguous term when it refers to unnecessary health regulations. The term necessary has a range of meaning from essential to merely useful. Casey did not explain the sense in which the term is used in this rule. In addition to these problems, one more applied to all 3 rules. They all call on courts to examine a law's effect on women. But a regulation may have a very different impact on different women for a variety of reasons, including their place of residence, financial resources, family situations, work and personal obligations, knowledge about fetal development and abortion, psychological and emotional disposition and condition, and the firmness of their desire to obtain abortions. In order to determine whether a regulation presents a substantial obstacle to women, a court needs to know which set of women it should have in mind and how many of the women in this set must find that an obstacle is substantial. Casey provides no clear answer to these questions. It said that a regulation is unconstitutional if it imposes a substantial obstacle in a large fraction of cases in which it is relevant. But there is obviously no clear line between a fraction that is large and one that is not. Nor is it clear what the court meant by cases in which a regulation is relevant. These ambiguities have caused confusion and disagreement. Let's see what people are saying. It's just an experiment after taking it out of the womb. That's the point I'm trying to make. There must be a balance between morals, intellect, emotion in a reasonable society. It's not just an experiment once it's out of the womb. I think it's a potential human life that deserves everything that a potential human life deserves, which is basically most things. I hate abortion. It's disgusting. I'm only born because of a tied tube reversal, and the baby before me was a miscarriage. Yeah, I mean, I don't know if that's the argument over how legislation should be, how it should be legislated, is very different than the argument over whether or not we should the courts how the courts should treat it. And frankly, I think the strongest argument is this is not something for the courts to decide. And frankly, I would probably have, if I were writing the decision, I would have only overturned Roe and left Casey, punted on Casey. And you can punt. Courts punt all the time. They could have just remanded. They could have overturned Roe and remanded the rest, and possibly even overturned Casey later, right? That's probably what I would have done, and I would have stuck to this is just judicial overreach. I believe that if you get pregnant, you have the responsibility to keep that child until birth. However, it is once the government requires one to provide their body to another, rape or incest. It's a difficult thing, honestly. I think it should be really simple to say that if the child can be removed, and it's going to live, then you don't have the right to put it to death. And that's what bothers me the most. This is awesome news. Awesome. Hi, Wicked Mini. Yeah, I don't know. Maybe. I certainly wanted Roe overturned. The leak bothers me to no end. It was, yeah. I'm talking about his idea on pre-viability with the experiment thing and the ever-changing technology with regards to using an artificial womb. Yes, it is a potential life, but morally, I'm at a loss. That's why I go with Jewish law, which says that potential life is important. States should have the say in this and in other matters. I certainly agree with that. The bigger problem is the leak. Is it has done serious damage to the Supreme Court as an institution, I think. The difficulty of applying Casey's new rules surfaced in that very case. The controlling opinion found that Pennsylvania's 24-hour waiting period requirement and its informed consent provision did not impose undue burdens. But Justice Stevens, applying the same test, reached the opposite result. That did not bode well, and then Chief Justice Rehnquist aptly observed that The undue burden standard presents nothing more workable than the trimester framework. The ambiguity of the undue burden test also produced disagreements in later cases. The court in Whole Women's Health versus Hellerstedt, the court adopted the cost-benefit interpretation of the test, stating that the rule announced in Casey requires the court consider the burden a law imposes on abortion access together with the benefits those laws confer. But 5 years later, a majority of the justices rejected that interpretation. 4 justices reaffirmed Whole Woman's Health instruction to weigh a law's benefits against the burdens it imposes on abortion access. But the Chief Justice, who cast the deciding vote, argued that nothing about Casey suggested that a weighing of costs and benefits of an abortion regulation was a job for the courts. And of course, he's chiding Roberts there. And the 4 justices in dissent rejected the lead opinion's interpretation of Casey. This court's experience applying Casey has confirmed Chief Justice Rehnquist's prescient diagnosis that the undue burden standard was not built to last. The experience of the Court of Appeals provides further evidence that Casey's line between permissible and unconstitutional restrictions has proved to be impossible to draw with precision. Casey has generated a long list of circuit conflicts. Most recently, the Court of Appeals has disagreed about whether the balancing test from Whole Woman's Health correctly states the undue burden framework. They have disagreed on the legality of parental notification rules. They have disagreed about bans on certain dilation and extraction procedures. They have disagreed about when an increase in the time needed to reach a clinic constitutes an undue burden, and they have disagreed on whether a state may regulate abortions performed because of the fetus's race, sex, or disability. This is actually that last one is the one that really bothers me. I think it should be absolutely illegal to perform an abortion based on race, sex, or disability. The Court of Appeals courts of appeal have experienced particular difficulty in applying the large fraction of relevant cases test. They have criticized the assignment while reaching unpredictable results, and they have candidly outlined Casey's many other problems. Casey's undue burden test has proven to be unworkable. Plucked from nowhere, it seems calculated to perpetuate give it a try litigation before judges assigned an unwieldy and inappropriate task. Continued adherence to that standard would undermine, not advance, the even-handed, predictable, and consistent development of legal principles. Effect on other areas of law. Roe and Casey have led to the distortion of many important but unrelated legal doctrines, and that effect provides further support for overruling the decision. Members of this court have repeatedly lamented that no legal rule or doctrine is safe from ad hoc nullification by the court when an occasion for its application arises in a case involving state regulation of abortion. A bunch of citations. The court's abortion cases have diluted the strict standard for facial constitutional challenges. They have ignored the court's third-party standing doctrine. They have disregarded standard res judicata principles. They have flouted the ordinary rules on the severability of unconstitutional provisions, as well as the rule that statutes should be read where possible to avoid unconstitutionality. And they have distorted First Amendment doctrines. When vindicating a doctrinal innovation requires courts to engineer exceptions to long-standing background rules, that doctrine has failed to deliver the principled and intelligible development of the law that stare decisis purports to secure. All that's true. If it is shot down, then the states have the decision, and if the federal government takes up the topic and passes a federal, then will it be like marijuana with regards to taking the state's side? I think so. I think so. I think principled conservatives would be opposed to a federal regulation. But what do I know? Okay. I am going to keep on going because there are, according to StreamYard, there are 5 people watching this, and we hopefully will be done soon. Reliance interests. We last consider whether overruling Roe and Casey will upend substantial reliance interests. Traditional reliance interests arise when advanced planning of great precision is most obviously a necessity. In Casey, the controlling opinion conceded that those traditional reliance interests were not implicated because getting an abortion is generally unplanned activity, and reproductive planning could take virtually immediate account of any sudden restoration of state authority to ban abortions. For these reasons, we agree that with the Casey plurality, that conventional concrete reliance interests are not present here. Unable to find reliance in the conventional sense, the controlling opinion in Casey perceived a more intangible form of reliance. And it wrote that people had organized intimate relationships and made choices that defined their views of themselves and their places in society in reliance on the availability of abortion in the event that contraception should fail, and that the ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives. This reminds me of a woman who told me that she was married and she had like 2 kids, and her 3rd kid, she had and she told me the condom broke. I took a morning after pill, still had the baby. But this court is ill-equipped to assess generalized assertions about the national psyche. Casey's notion of reliance thus finds little support in our cases, which instead emphasize very concrete reliance interests like those that develop in cases involving property and contract rights. When a concrete reliance interest is asserted, courts are equipped to evaluate the claim, but assessing the novel and intangible form of reliance endorsed by the Casey plurality is another matter. That form of reliance depends on an empirical question that is hard for anyone, and in particular for a court, to assess, namely the effect of the abortion right on society and in particular on the lives of women. The contending sides in this case make impassioned and conflicting arguments about the effects of the abortion right on the lives of women. Compare brief for petitioners, brief for amici, women's scholars, with brief for respondents, brief for National Women's Law Center as amici. The contending sides also make conflicting arguments about the status of the fetus. This court has neither the authority nor the expertise to adjudicate those disputes. And the Casey plurality's speculations and weighing of the relative importance of the fetus and mother represent a departure from the original constitutional proposition that courts do not substitute their social and economic beliefs for the judgment of legislative bodies. Our decision returns the issue of abortion to those legislative bodies, and it allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. Women are not without electoral or political power. It is noteworthy that the percentage of women who register to vote and cast ballots is consistently higher than the percentage of men who do so. In the last election in November 2020, Women, who made up around 51.5% of the population of Mississippi, constituted 55.5% of the voters who cast ballots. Unable to show concrete reliance on Roe and Casey themselves, the Solicitor General suggests that overruling those decisions would threaten the court's precedents, holding that the Due Process Clause protects other rights. That is not correct for reasons we have already discussed. As even the Casey plurality recognized, abortion is a unique act because it terminates life or potential life. And to ensure that our decision is not misunderstood or mischaracterized, we emphasize that our decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. Having shown that traditional stare decisis factors do not weigh in favor of retaining Roe or Casey, we must address one final argument that featured prominently in the Casey plurality opinion. The argument was cast in different terms, but stated simply, it was essentially as follows. The American people's belief in the rule of law could be shaken if they lost respect for this court as an institution that decides important cases based on principle, not social and political pressures. There is a special danger that the public will perceive a decision as having been made for unprincipled reasons when the court overrules a controversial watershed decision such as Roe. A decision overruling Roe would be perceived as having been made under fire and as a surrender to political pressure, and therefore the preservation of public approval of the court weighs heavily in favor of retaining Roe. This analysis starts out on the right foot, but ultimately veers off course. The Casey plurality was certainly right that it is important for the public to perceive that our decisions are based on principle, and we should make every effort to achieve that objective by issuing opinions that carefully show how a proper understanding of the law leads to the results we reach. But we cannot exceed the scope of our authority under the Constitution, and we cannot allow our decisions to be affected by any extraneous influences, such as concern about the public's reaction to our work. I fundamentally disagree with this. I think what he should have been arguing is that this has made the judicial branch political, and that's why it should be overturned. But that's not the argument that he's making. That is true both when we initially decide a constitutional issue and when we consider whether to overrule a prior decision. As Chief Justice Rehnquist explained, the judicial branch derives its legitimacy not from following public opinion, but from deciding by its best lights whether legislative enactments of the popular branches of government comport with the Constitution. The doctrine of stare decisis is an adjunct of this duty and should be no more subject to the vagaries of public opinion than is the basic judicial task. In suggesting otherwise, the Casey plurality went beyond this court's role in our constitutional system. The Casey plurality called the contending sides of a national controversy to end their national division and claimed the authority to impose a permanent settlement on the issue of a constitutional abortion right simply by saying that the matter was closed. That unprecedented claim exceeded the power vested in us by the Constitution. As Hamilton famously put it, the Constitution gives the judiciary neither force nor will. Our sole authority is to exercise judgment, which is to say, the authority to judge what the law means and how it should apply to the case at hand. The court has no authority to decree that an erroneous precedent is permanently exempt from evaluation under traditional stare decisis principles. A precedent of this court is subject to the usual principles of stare decisis, under which adherence to precedent is the norm, but not an inexorable command. If the rule were otherwise, erroneous decisions like Plessy and Lochner would still be the law. That is not how stare decisis operates. And I would actually bring up Korematsu here. The Casey plurality has misjudged the practical limits of this court's influence. Roe certainly did not succeed in ending division on the issue of abortion. On the contrary, Roe inflamed a national issue that has remained bitterly divisive for the past century. See also Ginsburg speaking in a judicial voice, right? Halted again, second time. And for the past 30 years, Casey has done the same. Neither decision has ended debate over the issue of a constitutional right to obtain an abortion. Indeed, in this case, 26 states expressly ask us to overrule Roe and Casey and to return the issue of abortion to the people and their elected representatives. This court's inability to end debate on the issue should not have been surprising. This court cannot bring about the permanent resolution of a rancorous national controversy simply by dictating a settlement and telling the people to move on. Well, I mean, there was Obergefell. Whatever influence the court may have on public attitudes must stem from the strength of our opinions, not an attempt to exercise raw judicial power. We do not pretend to know how our political system or society will respond to today's decision overruling Roe and Casey. And even if we could foresee what will happen, we would have no authority to let that knowledge influence our decision. We can only do our job, which is to interpret the law, applying long-standing principles of stare decisis, and decide this case accordingly. We therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. Okay. We must now decide what standard will govern if state abortion regulations undergo constitutional challenge and whether the law before us satisfies the appropriate standard. Under our precedents, rational basis review is the appropriate standard for such challenges. As we have explained, procuring an abortion is not a fundamental constitutional right because such a right has no basis in the Constitution's text or in our nation's history. It follows that the state may regulate abortion for legitimate reasons, and when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. That respect for a legislature's judgment applies even when the law at issue concerns matters of great social significance and moral substance. A law regulating abortion, like other health and welfare laws, is entitled to a strong presumption of validity. It must be sustained if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. These legitimate interests include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. These legitimate interests justify Mississippi's Gestational Age Act, except in a medical emergency or in the case of a severe fetal abnormality. The statute prohibits abortion if the probable gestational age of the human being unborn human being has been determined to be greater than 15 weeks. The Mississippi legislature's findings recount the stages of human prenatal development and assert the state's interest in protecting the life of the unborn. The legislature also found that abortions performed after 15 weeks typically use the dilation and evacuation procedure, and the legislature found the use of this procedure for non-therapeutic or elective reasons to be a barbaric practice, dangerous for the maternal patient, and demeaning to the medical profession. These legitimate interests provide a rational basis for the Gestational Age Act, and it follows that respondents' constitutional challenge must fail. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Roe and Casey arrogated that authority. We now overrule these decisions and return the authority to the people and their elected representatives. The judgment of the Fifth Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. And then there are appendices. I see no questions from people. I am going to spend the next 15 minutes or so looking at Twitter to see what's going on. So this is what I wrote 5 hours ago. My guess is that Robert switched sides to write a milder opinion. The leaker prefers an opinion more likely to be struck down with fewer votes. That's what I'm thinking. It's trending. We'll take a look. But I wanted to show this meme. Democrats in 1861 wearing a Confederate cap. You can't say they're humans who have rights. Democrats in 2021. You can't say they're humans who have rights wearing a women's thing. And it's apparently from Mostly Peaceful Memes, which is a funny thing. This one was really ugly. So SCOTUS blog says it's impossible to overstate the earthquake this will cause inside the court in terms of the destruction of trust among the justices and staff. This leak is the gravest, most unforgivable sin. Anne Murphy, who apparently is a professor of law at Gonzaga, says the sin is the opinion. And RJ Kassam from National Pulse, who I follow, says, you are a professor who is publicly confessing to having a greater fealty to your public opinions than the rule of law and the sanctity of the institutions that protect it, which is correct. And then I think this is where I got the thing. And somebody mentioned, I think Gonzaga is a Catholic university. Gonzaga, is it? Private Jesuit university. So she's a professor at a Jesuit university. I don't know why I can't see the response. Probably Twitter lost its mind. Who knew that simply disagreeing with an opinion meant all that? Absolutely nutty response here, RJ. Yeah, bullshit. Save some of that outrage for the ruling itself. Yeah, that's... I mean, he's right. Did I... anything else? No. So let's look at trending. The Guardian has a stupid opinion. How campaigners reacted to report on... okay. Here's where abortion will disappear if the Supreme Court overturns Roe v. Wade. And it's all red states. I mean, Texas is the only one. I mean, Georgia, we looked at the thing. I mean, how many abortions were being had in Utah, really? Kirsty Noam of South Dakota vows to secure a right of life. Okay. Abortion would remain legal in about half of U.S. states if Roe v. Wade was overturned, but the rest would likely ban the procedure. The number of abortions would probably fall, particularly among poor women in the South and Midwest. the New York Times says something that's not stupid for once. Los Angeles Times. As the U.S. Supreme Court is poised to overturn the nation's landmark abortion rights protections, Governor Newsom and legislative leaders said that they will ask voters in November to place permanent protections for the procedure in the California Constitution, as if it's even a thing. Okay, protesters are brawling outside the Supreme Court. What else is new? Within hours of the news that the U.S. Supreme Court may overturn the Roe v. Wade ruling that legalized abortion nationwide, abortion rights supporters in Washington called on Democrats in Congress to take action to protect access to abortion. Can't do that. That's not going to work. Experts say the leak of a U.S. Supreme Court draft opinion that would overturn the constitutional right to abortion is a major breach of confidentiality that has heightened the stakes in an already politically charged case, reports Andrew Chung. Yeah. Honestly, this is the thing. Ruth Bader Ginsburg could probably have saved Roe v. Wade by retiring. Okay. Go ahead and throw her under the bus. Here's what you need to know about landmark decision in 1973. Not much. It's been overturned. California aims to be a national haven for abortion rights as Roe v. Wade appears doomed. The Los Angeles Times being stupid. In statement, an appalling attack on the rights of women and coat hangers, of course. I have no idea who Jimmy Hoover is. I do not follow him. Supreme Court editor at large for Law 360. Great. I'm not a fan of Law 360, if it's what I think. In 2020, Alito chided SCOTUS for rough treatment of a 72 case, lowering the bar for overruling our precedents, he said. The court casts aside an important and long-established decision with little regard for the enormous reliance the decision has engendered. I'm gonna guess that the reliance wasn't on nothing. Someone should have asked him directly if he wants to unsettle it. Can't help thinking that Kavanaugh said Roe v. Wade was settled law. The fact that every justice is asked about Roe v. Wade is exactly why it needed to be overturned. I pulled up the protests going on in front of the court. The best thing I heard was abolish the court. It was hilarious to hear. Florida will probably write up a law to ban abortion up to a certain extent, but not fully due to Disney and high Democratic cities. Actually, so the Republicans are really going after Disney. Even more, they went after the FAA thing. I'll say thank you now. You are quite welcome, Zurich. I'm not sure if you've been here before, but you are quite welcome. I only caught about an hour, but thanks for your analysis. My pleasure. We've been going for four and a half hours almost. I'll keep on going as long as people are watching, but not many people are watching anymore. How many does StreamYard? StreamYard says there are 6 people watching. Somebody joined on Twitter watching. I mean, Twitch. People don't watch on Twitch very often. Okay, where were we? We were looking on Twitter for hot takes. Anti-abortion activists and pro-abortion supporters took to to the streets of Washington after news that the U.S. Supreme Court may overturn Roe. Both sides of the abortion debate were inflamed on Monday night after news leaked of a draft decision. Well, this is the New York Times trying to be inflamed. Please tell me that it's not Hassan Piker who is the cause of the trending. Probably is. Nepotism Barbie hits again. We'll take a look at that, the trending later. If Supreme Court leak story is true, it would seem to me someone with a motive clearly leaked it. Pretty obvious there. Hundreds gathered in front of Supreme Court on Monday night following the news about a leaked opinion indicating that a majority of the court is prepared to overturn Roe v. Wade. Okay. Political reports. MSNBC. A crowd of people gathers outside the U.S. Supreme Court following a political report on what it says is a draft opinion showing the U.S. Supreme Court striking down Roe v. Wade. Newsweek. Roe v. Wade protests as furious abortion activists swarm Supreme Court. Okay. Protesters gather outside the U.S. Supreme Court after Politico publishes. Yeah, okay. Democrats denounce Supreme Court's leaked decision to strike down Roe v. Wade, with some promising to fight to preserve abortion rights. Well, go ahead, do that. Against abortion, get a vasectomy. Okay? The disclosure of a draft majority opinion that indicates the Supreme Court has voted to overturn instantly jolted Democrats. And any hope it could change the tide of the midterm elections. This kind of outcome is exactly what I've been ringing alarm bells about, and this is a 5-alarm fire. Senator Patty Murray, the chamber's number 3 Democrat and leader of its health committee. Okay, whatever. The Republican-appointed justices reported votes to overturn Roe v. Wade would go down as an abomination. Okay, Catholic Speaker Nancy Pelosi. One of the worst and most damaging decisions in modern history. Speaker Nancy Pelosi and Majority Leader Chuck Schumer said in a joint statement. Let's see what this joint statement looks like. Joint statement. Where's their joint statement? Joint statement. I'm not seeing a joint statement. Where? Okay, I have no idea what a joint statement is. It's probably stupid. Let's see what the comments here say. I guess if the people that are actually supposed to make laws don't want to, then blame the people that weren't supposed to. SCOTUS can't stop you from actually passing a law that says murder is illegal. This is true. I agree with that. Is this somebody I follow? No, it's not. I'm just going to say it right now. Women should be allowed to kill whatever is growing in their body, and men should be allowed to take a step back without being forcefully put into child support if the woman decides not to kill. Not a huge fan. Murder advocates trying to justify murder right now. Yeah. Federal constitutional right to abortion was legal frivolity de jure and logical fallacy de facto. Heavens to every Betsy and each Murgatroyd on SCOTUS for their resolve. Barbarians chasing women, families pregnant must be curbed and stopped as ruthlessly as ambulance chasers. Okay. Roe v. Wade was a farce. What are you smoking? There was never a bill that got 60 votes. It won't, sadly. Partisan normie Dems will be energized, but the left will sit at home stewing over Biden not signing a bill codifying Roe that got 60 votes. They have lost trust with Dems on this issue, and as long as inflation is in mind for white people, I'm just happy he only has 78 followers. This ruling doesn't exist. Imagine being so racist that you think it is white people being white that stopped Planned Parenthood from genociding black people. Nancy Pelosi is supporting an anti-choice Democrat in Texas. Swing on over to her office for an effing comment. Any move the court made short of ruling the law unconstitutional was going to create waves. This leak makes it worse for America. Dems may win in the midterms now, but America loses in the end. We will be divided. No president can change that reality, especially not this one. I guess this is a Democrat. I would rather stand with God and be judged by the world than stand with the world and be judged by God. I agree with that. Who leaked this? A complete breach and unprecedented lack of decorum in SCOTUS. This needs to be investigated. Name your sources. Doesn't matter now. The U.S. is a falling empire. We are divided, and nothing short of a miracle will unify the two sides. Centrists are disappearing and choosing sides now too. When this decision happens, expect people to raise hell. Same-sex marriage is next, by the way. No, actually, same-sex marriage is not next at all. By the way, vast majority of people really don't care about same-sex marriage. That's why, or people really don't. Okay. Pro-life. Let's see if anybody's saying anything. Oh, hey, Richard. Yes, I'm sorry. That Richard. Yes, you did show up on my Discord recently. And you're welcome on my Discord. So he's the guy who, I guess he's the one who got the exclusive. No draft decision in modern history of the court has been disclosed publicly while a case was still pending. The unprecedented revelation is bound to intensify the debate over what was already the most controversial case on the docket this term. Yeah. Whatever happened to the separation of church and state? Freedom of religion includes freedom from religion. That this might be the dumbest opinion anybody has expressed. Let's find a good. That's as good a GIF as I can muster right now. I can't believe where this country is going. Backwards. Saving lives equals going backwards? Basically. Abortion is not in the Constitution. The pending SCOTUS decision will kick the issue back to the states, not outlaw it. This is true. We are in a cold civil war. Unfortunately, this is also true. Anybody reminded of prohibition? No. No, not even close. This is the exact opposite. Idiots. The fact that this draft was leaked is a tsunami to the guardrails needed by the democracy of an independent, non-political branch of government. Disgusting, frightening, and ultimately sad. I agree. Pro-life equals pro-control. You will do what we say when we say with your body. Rape, incest, human traffic, that these are your fault. We will control you. New GOP 2022. If you had a real point, you wouldn't need to lie. USA Christian Taliban. Oh yeah, that's the tweet that somebody shared with me. This guy claims to be a rabbi, so let's show you his beautiful tweet. Rabbi Mike Harvey. Judaism me chaplain PhD student. I have to wonder. Oh, I think this is the guy who was recently. Is this the guy who was recently shown not to be Jewish? Anyway, F Christians and their never-ending imperialistic, nationalistic, fascist patriarchy that puts people's lives at risk. And doesn't give an S of what anyone or science says. Shame on all who hold the cross. 2,000 years of your genocide continues tonight. F you. Please don't call that rabbit a rabbi. Thank you. The Jewish people. Yeah. See, okay. This is the type of thing that makes me hate rabbits. You seem nice and not insane at all. Yep, true. Your Honor, as you can see from the documented evidence, the hoes are indeed very well. After carefully reading the evidence, I've reached the verdict. I find the defendant Hose guilty of being. What if I believe abortion is wrong because a sperm fused with an egg has formed a unique, unrepeatable human organism that no other human being, including its mother, has a right to murder? All that is science, no religion in it. Yeah, that's why. What's his name? Ben. What's his name believes. So what is your take on this? My take on it is the leak is horrible. The decision is okay. The ramifications, I don't know. So after 4.5 hours, that's basically my take. If I were king of the world and I was writing the decision, I would have overturned Roe, but not Casey. That's what I would have done. And I think there was plenty of room for them to do precisely that. I would have punted Casey, overturned Roe, punted Casey, and then possibly overturned Casey later, which would have been just as easy to do and would have been a more judicially restrained way of doing things, I think. For those who love us, for those who hate us, may God forgive us both. Amen. Worrying about salvation is. Hello, Moloch. Yeah, basically. It doesn't. Okay. Yes, it does. Yes, yes, it actually does. Yes. It does. So Genesis 9, I want to say. Genesis 9 6. Genesis 9 6. In the Hebrew, shofech dam ha'adam ba'adam. Right? 9 6. Whoever spills the blood of a person within a person. And yes, I am quoting from a Talmudic interpretation. And if he is a rabbi, which I doubt. Who is this guy? Podcaster. Time to go to war for our mothers, sisters, and daughters. We will not stand by and allow a group of white Christians to turn America into the Dark Ages again. Not this time. You are racist, and I doubt very much you would know an Aleph from your toughest. Oh, did he? I'm sure he already. No, he hasn't. You are racist. And I doubt you know an Aleph from this. Huh. Why is it not letting me? He hasn't blocked me. Oh, it's. Oh, he locked it down. That's what happened. Anyway, I have no idea why I'm paying attention to this guy. Let me see if I can find out who he is. Rabbi Mike Harvey. Ordained rabbi and social justice advocate. Of course. Idiot. Where did he serves as chair of the Indiana Board of Rabbis? Who made up the Indiana Board of Rabbis? Hebrew Union College. Why am I not surprised? He's a reform rabbit. just to be clear, this racist idiot is a reform rabbit. Real rabbi. Okay. We were. So you are not okay with abortions? No, I am not okay with abortions. If an abortion is necessary to save somebody's life, that's different. To have an abortion just to have an abortion, that's evil. Just trying to clarify. Why is your religion and the beliefs in your religion have more precedent in other lies? I'm not sure what you're referring to, but Judaism has always had standards that we believe Jew and Gentile should live by, the Noahide laws, which are really simple and understandable laws. And included in that is do not murder. Oh, I was quoting the Old Testament. Yeah, that particular verse. That particular verse, Genesis 9:6, is part of the covenant of Noah. In fact, it's the most explicit part of the covenant with Noah. So in Judaism, we believe that applies to all of humanity. Let's see. Ooh, let me see what. Let's see what Andy No has to say. It's time for a revolution. Candidate for Florida Attorney General calling for After the draft Supreme Court was leaked, fencing was put up around the court to protect it. Hundreds of angry pro-abortion activists gathered around calling the justices fascist scum. Yeah, not surprising. Okay, let's see what Glenn Greenwald has to say. Glenn Greenwald. Okay. I do like Glenn. And Stephen Miller. They're both interesting people. Let's see. So Guy Benson said, regardless of what one believes about whether the court ends up, whatever the court ends up ruling on Roe, which I think was wrongly decided in the first place, and abortion policy should be returned to states' representatives. The leak, if authentic, is a shocking low moment for the institution. Correct. They don't care. The norms go in one direction. He's also right. But Guy Benson is definitely right. The next opinion day, it has if this is a general, heads should roll. Well, if they find out who it is. I can't imagine this is not a genuine. It would be. I can't imagine this isn't genuine. Lots of people are making this point thinking it's clever, but Sotomayor said at her hearing that Heller was settled law, then dissented in McDonald, which just incorporated Heller to the states. Promised to know who would overturn it, and then goes on, whatever. Stupid. Lots of biologists selling fine. See, this is why I like Stephen Miller. He's at Red Steez. He's funny. He is funny. Too bad Dr. Rollergator. Not surprising, but still outrageous. This decision is a direct assault on the dignity, rights, and lives of women, not to mention decades of settled law. It will kill and subjugate women, even as a vast majority of Americans think abortion should be legal. What an utter disgrace. Then why don't you just pass laws? If it's vast majority, just pass the laws. She was right about absolutely nothing. U.S. Ministry of Truth. I like this. We support the strong progressive vision you provide, Madam President. Those innocent children don't stand a chance. This is another account I highly recommend. You could log off right now. You could put the phone down, go to bed, and rest in peace from this dumpster fire, but you won't. Yeah, it's almost 1 a.m. I think I'm going to stop at 1. How many people are watching? 7 people are watching. Go to bed, people. No matter what you view in these protests, until it happens, nothing will be worse on what happened on January 6th. Either way, your religion doesn't take precedent over other people, life, and what they do with it. I disagree. I have minimum standards for all of humanity, and those are based on my religion. And yes, those minimum standards do apply to all of humanity. I am surprised you're still going, Jacob. It must be getting late in California as well. It is almost 1 a.m. But there are 7 people watching. How can I leave an audience of 7 whole people? That's like more people than have paid attention to me in my entire life. Well, that's not absolutely true, but it's close. Begin schedule to. I really like this account. Please pay no attention to the disinformation board, the high record inflation, the confirmation of Hunter Biden's laptop, or the microplastics report. I didn't know there was a micro. Pay no attention to the $33 billion to Ukraine, to POTUS's obvious dementia, or the change in social media power. Yeah. Orient your body towards the nearest screen with the political leaked report. Begin screaming. Party members are watching to ensure your participation. This account deserves 200,000 things. And apparently they have a website too. $15 shirt. I want one. If somebody wants to buy me one of the shirts, please do. Dr. Rollergator, I'm pretty sure it's still. Is he still? Yeah, I'm pretty sure he's still from February 21st. And of course, the Babylon Bee still locked out? Yeah, since March 20th, they're still locked out. Notifications. Actually, an excellent guess. Especially what we are pretty sure happened in the first ACA case. Let's see. Who else has interesting opinions? Do you think Elon Musk said anything? Elon, 12 hours ago, as I was saying. Well, that's interesting. I have no idea what that means. Okay. Let's see if he replied to anything. Let's see. Did he say anything? God, I hate Twitter and all these a-holes. What a stupid app. 27. This is true. This is very true. Let's see what this Hassan is. Mehdi Hassan. Elon Musk slams NBC for calling Republicans neo-Nazis, censoring after calls him a petulant, not so bright billionaire. Who cares about Mehdi Hassan? There's nepotism Barbie. Let's see what nepotism Barbie has to say. He did this and also didn't urge RBG Breyer to retire, so don't let anybody get away with any of that. Obviously, Republicans are demons, but let's not act like the Dems are all that great either. Establishment Democrats should be asked about this every single day, in my opinion. Well, you're an idiot. I don't know Liz Wheeler, but yeah, I mean he's kind of right. She's kind of right. Pray for all the girls and women who will become second-class citizens when their reproductive rights are overturned. Go away. I've never browsed Twitter. I'm glad I've been able to vicariously experience this hellhole I've heard so much about. Yeah, I really shouldn't Twitter, but I do. Good night. If overturned, I'm envisioning another summer of love situation. Oh, you mean if this was overturned? I guess. This goes against the GOP slogan of "Party of Small Government." Not really. And honestly, I'm not. Look, saying that murder is wrong is not. I mean, murder is wrong. A friend of mine is a court advocate for a young girl raped by her father. Thankfully, she's not pregnant. But I'm going to pray for girls in similar situations who are, again, an absolute lie. If you had a point, you wouldn't need to lie. I guess I should look at Planned Parenthood and see them crying. Planned Parenthood, which global. Let's see what they have to say. Let's be clear. This is a draft opinion. It's outrageous. It's unprecedented, but it's not final. Abortion is your right, and it is still legal. Get your abortions now while you still can. No, I just wanted to actually see the retweets. I didn't actually want to retweet it. Quote tweets. There we go. Not happened yet. And now is the time. Too late, guys. Your sacrifices to Moloch are ending. Cry now. those aren't nice things at the end right there. If it evolves from opinion to decision, call for general strike for women and those who support them. Put the decision to a national referendum. Let the will of the majority speak. The whole problem you have is the fact that the majority of people don't like third birth abortions and aborting children. It's just in there. Well, this wasn't on my bingo card. Okay. I don't know what is. Senator Joe Nguyen from Washington State Senator. Protecting abortion and reproductive rights has been our priority since we won the majority in 2017. We need Congress to do the same because this draft position is effing shameful. This is so horrible. If this is allowed to pass, not only millions of American women's lives will be put in danger, but also I fear this would be the thing that will break the West's focus on Ukraine, making their situation harder too. Who is this person? EU Stan account. Okay, it's always people. Okay, it must be a, yeah. This is a whatchamacallit. It's a oh, Bob Hertzberg. He's actually my state senator. This leaked document is truly terrifying, horrifying. Let's channel our anger and despair into action to restore the civil rights being eroded before us. We must fight like there's no tomorrow and never give up. God. This won't stop abortions. This is right. Like Trump will still pay for doctors to do them. She's right. Poor women who can't afford a child will resort to back alley butchers. I mean, if women are forced to have a child, the man who impregnated her should be involuntarily castrated. Come on. There is adoption, you know. Abortion is a human right. What's the Packard Foundation? David and Lucille Packard. I have no idea who these people are. We remain steadfast in our commitment to building a world where all people can make decisions about their own bodies and lives and access to essential health care they want and need. They don't make decisions about the baby's life. You have nothing to worry about. Bottom line, these far-right folks would not step up to care for these children or women who they force to be the birth mom or be held responsible for the loss of lives. Folks like what I might have been. They will just look away. Not true. Pro-life are more than willing to adopt all these children, including the children who are sick and wanted. No. Zuby's razor. They will not reverse it. Brad Sherman, he's one of the local guys around here. A stark and sobering reminder that the clock is ticking down to the end of legal abortion. I voted to codify Roe in whatever that is. The Senate must make it law, and fight to uphold abortion rights must continue. In the meantime, remember, abortion is still legal and is still a right. It is legal, but it is still a wrong. The right to make private medical decisions about reproductive health care has stood in law for 50 years. GOP has pushed its power and control agenda far too long, treating women like children. The GOP plan to strip women's rights is in full view with court political appointees. Fight. Yeah, we did know this was coming. As a physician, I know more than anyone that medical decisions belong in the exam room. A woman still has the right to choose. Get out and protest if you can, people. What's that going to do? This isn't over, but the direct attack on women and civil liberties can't be denied. Our power is at the ballot box. Dems must win to keep the House and Senate this November. The House and Senate has nothing to do with this. So we can stop this court from continuing to strip away our rights. Women are far beyond capable of making the best decisions for their own bodies. Government has no place here. Their own body. Okay, I really should get off Twitter. And it's 1 a.m. Let's see. Recurrent topology. Have you been here before? We agree that murder is wrong, but I disagree that a fetus is a person, therefore cannot be murdered. I think a viable child is definitely a person. Well, yeah. I still think it's enough that it's not. It shouldn't be a thing, because that is in your religion. Not everyone follows it, so not everyone should abide by whatever is written in those books. I disagree. There is minimum morality, and my religion demands that this. And I look at Jordan Peterson. Like, no, we have to have morality. We must have morality. And you can disagree if you like, but this is basic morality. Don't kill people. From a Christian point of view, I think of biology and apply my morals to such ideas and results from what science has given us. Not a huge fan. Honestly, I think Paul of Tarsus, or as I like to call him, Ball of Tarsus, went way too far, claiming that now that you can't have the spirit without the law. You have to have a law. And this is why Christianity has been backpedaling from Paul since forever. Not every child gets adopted, and the cost associated with are high. What an asinine take. It's not true. It's absolutely not true. There are no babies. If you want to adopt a baby, you have to go on a wait list. There are no babies, none available. What no one proposing legislative solutions, either a federal ban or codification, seems to realize is that these bills will end up in the courts as well. Yeah. And honestly, federal bans, I cannot imagine there that courts will allow those. You really don't see the irony of your religion being pushed on others do what is right by it. Freedom of religion applies to everyone. Freedom of religion does apply to everyone. That's beside the point that there is a basic morality. You have to have a basic morality. If you don't understand that you can't say, oh, freedom of religion, I get to murder people, you're just being stupid. I'm sorry. GOP will lose seats in the election due to this. No. See, that's the actual thing. Um, the Democrats have consistently been losing politically over this. And like the mainstream media just pretends like it's not true. And it's like this has been a losing issue for Democrats for and honestly, I think the Democrats would be better off if they dropped it, but they can't because they're captive to that um, very particular, very small leftist thing. Doesn't matter. You realize that. What doesn't matter? Again, no one is saying you can murder people. This is just a disagreement about what a person is. I mean, let's go back to this. Where's that meme? Democrats 1861. You can't say they're humans who have rights. Sorry, but no, you don't just get to define away human beings. You just don't. And that is basically what the Democrats did during slavery, and that's what they're doing. They're defining away humanity. How you think that's going to be on the right side of history, which the Democrats constantly talk about the right side of history. The secularism you seem to advocate, lower than average, is more a French than an American version. The complete banning of religion from public discourse and life is not very American. Yeah. It's there. This is a very modernist secularism. And you're right, it is more French than it is Anglo-American. And it's a silly secularism. It's a secularism that is has an animosity towards religion. It's not freedom of religion, it's freedom from religion. It's directly saying because you are religious, you must be discriminated against, which is silly. People will vote Dem because they are who is likely to agree with abortion rights. Yeah, but vast majority, but that's the problem. the people who are for abortion rights will vote Dem. That's what's been losing the Democrats election after election. Yeah. Not sure if you've been here before, Jodor. As a Christian, do you believe in an age of accountability? Most people would not consider me a Christian. I do believe in an age of accountability. If a child is born but dies before they can understand heaven and hell, do they go to heaven? So I'm Jewish, and we do believe in reincarnation. And if a child dies before accountability and is never reincarnated, which doesn't make much sense in Judaism, then they certainly wouldn't go to hell. I am disagreeing with his religion in general and how others should abide by it. The government should have no say or write bills based off religious beliefs. Then how do you get a prohibition on murder? The prohibition on murder is religious. The prohibition on slavery is religious. The prohibition on pretty much all morality has to be based, because again, Hume, you cannot get to an ought from an is, and all law is on a framework of religious values. You can't have values um, without religion. It just doesn't exist. And yes, I am saying atheists are immoral. It is a secularism that bans Islamic dress in public, for example, which is something that would and should never happen in America. Right? It's yeah. Well, so then those who are religious should be banned from public life, obviously. I believe in separation of church and state. I'm not religious, but there are no tests for office, clearly. Yeah. Yep. Atheists are immoral. It's just true. Morality exists without religion. You can choose to be moral even without a higher power. You can't define your morality. That's the problem. There is no definition of morality. And what really happens is that atheists will default to the morality that they were taught in a religious society. See, for example, Tom Holland's book Dominion. Tom Holland has great. I mean, he really discusses this, and as an atheist himself, he explains that it's. I mean, all these atheists, they're Christian atheists. They just don't know enough to understand that. You can have integrity without a God guiding you. Yeah. What makes murder wrong? Why shouldn't I chop up people for parts? This is the ABCs of philosophy. Just because nobody studies theology in the United States or philosophy doesn't mean. I mean, these are just basic facts that anybody who's actually thought about things knows. But whatever. You can choose what your definition is. Exactly. It's immoral. You can choose whatever you want. That's the problem. It works the same way with religious people who choose to believe their religion's morality. Yeah, so there's no difference between your morality and my morality. So how do we choose morality? I chose my morality based on religion. You have no basis whatsoever for your morality. Not getting anywhere. I don't need a God saying I shouldn't murder someone. I would just never do it. That's what you think, but that's because you're a Christian atheist. Is that a hard concept? Yeah, it actually is. Again, I highly recommend the book Dominion by Tom Holland. I think it'll help you understand better. He also has lots of videos on YouTube, but Christian atheists just don't understand how Christian they are. And it's like, okay, you have no clue why you believe the things you believe, but yeah. When I die, I lie in the ground, nothing happens to me. Okay, what does that have to do with the conversation? Again, I really wish we had a thing. Are you a natural law guy, Jacob? My guess is not, since that clashes with your definition of divine revolution. So the problem with natural law is again where the naturalistic fallacy. How do you get to the ought from your is, right? Just because, natural law, Sparta could have claimed natural law. They would put disabled people to death. And in fact, that's what happened with the atheist materialism, right? That's what the communists did, and that's what the Nazis did. Although the Nazis weren't really atheists, they were more Gnostics. But, natural law, I think, while I will argue it, I think ultimately it's a cop out. It doesn't work. I choose it based on my philosophy. My belief is in what's right is no more valid or invalid than yours. It is a belief. That is existentialism, and that's, I mean, there are definitely existentialists. The problem with existentialism is ultimately it just doesn't give you a reason to get out of bed. I'm think the discussion that what's her name, that memetics woman had with Jordan Peterson. I forget what it is. I understand my morality has a Christian historical tradition, and I choose to believe it, even though I reject the supernatural. Yeah, so you actually understand what you're saying. Lower than average is a little lower than average. What was her name? Memetics. What's that woman's name? Susan Blackmore, that's it. Susan Blackmore had a video conversation with Jordan Peterson. It's on YouTube. It's a pretty good one. I recommend it. Explain why your religion and its views and beliefs should also guide my life, because it's correct. The reason to get out of bed is because I want to live a good and happy life. But why do you, first of all, okay, explain to me why, for example, it was Mother Teresa's life better than Amy Winehouse's life? If you can explain to me why Amy Winehouse's life wasn't better than Mother Teresa, we can talk. But until you can do that, and basically nobody can, I mean, how does Jordan Peterson put it? If like it's all about being happy, then heroin with a bullet chaser. As a Catholic, I believe that Jesus died for my sins. Nobody can die for your sins, and that's actually not a truly Catholic belief. We've actually been discussing this. So you're make sure that you're not believing in penal substitutionary atonement, which is the Protestant belief that the Catholic Church actually calls a heresy. So be really careful what you mean by Jesus died for your sins. I don't listen to everything that is said in the Bible and other texts. I apply my own moral framework and logic to it to make decisions. Sounds like you might have a lot more Protestantism in your beliefs than you might realize. I choose a moral system over the nihilism, though I see the legitimacy of nihilists. I don't. I think that. So I call it Jacob's razor. It's kind of a combination of Pascal's wager and cogito ergo sum. I think therefore I am, which is that which is necessary for life is an I hope I didn't insult you, recurrent topology. Lower than average? He's lower than average. You seem to actually be thinking. And honestly, I mean, if somebody's being dumb, I will insult them. I think we really need to. But Hitchens demolished Mother Teresa. I know you're joking. I am happy with my life. So does that make me better than Holy Mother? Um, eh. Amy Winehouse seemed sad, stressed, unfulfilled. I need to feel I'm helping people to feel good. Um, Honestly, I think that's your Christian. That is your Christianity coming through. Um, Tom Holland, I think you would like him. I think you would like him. Maybe her life was better for her, but not for me. Honestly, I think topology. I think if you were to pay, you should join this corner of the internet's discussion stuff. Um, I think you would find that interesting. Oh, look, somebody! It's Claire Kaw, my nemesis. Well, she's not really my nemesis. How to derive an ought from an is. The Quran is God's law. Therefore, we should obey his laws. Okay, nobody take Claire seriously. She is a postmodernist performance artist. So be really careful. No, I am debating with the same nuances that you follow in your religion. Honestly, not worth it. Christianity is idolatry and blasphemy. Okay, guys, it's 1:30 in the morning. There's still 5 of you watching this. It's like 5.5 hours into this. I have more content on my channel. I have tons of content on my channel. Go watch, see if you like. Recurrent topology. Are you part of this little corner of the internet or not? Because I think you would have interesting discussions with the rest of us. You seem to be a thinking person. Interesting seeing this from the other side. Have a good night. Good night. And you are certainly welcome to come on. Let me put a link to my Discord server. This little corner of the internet does spends most of its time on Discord, I would say. Where was it? Okay. So you're not going to see anything until I'm probably going to sleep. So I'm not going to, unless you join this very minute, I'm not going to be able to give you a role. But Anthony, I thought you were already on my Discord server. How come you're new? I was pretty sure you were already on my Discord server, no? Recurrent topology showed up. Okay. Okay, guys. I am going to go to sleep. Prime Donut. I have no idea who Prime Donut is. Okay. I am going to go to sleep. Yes, the link works. But I knew you from somewhere, Anthony, didn't I? Are you on Bridges of Meaning? I thought I knew you. You've been on the channel before, right? Yeah, you're on Bridges of Meaning. Okay. Yeah, I don't whatchamacallit. I don't poach people off Bridges of Meaning. Tom Holland conflates Christianity with liberalism, therefore we should ignore him. He's right. Yeah, PPKs, yeah. Okay, so I knew you from someplace. Okay, people, it's 1:30. I still have to drive home. I will see you guys later. And feel free to discuss on my Discord server. Please don't destroy it. I'll talk to you guys later.